vulnerable 2.30 to show us.
Officer still stands for time? No. Offender in custody? Very simple. Anyone else close with you? Let me know.
Interpreting complex DNA profiles can pose many challenges and introduce interpretation errors. A study conducted by Taylor explored the impact of DNA mixture interpretation and the accuracy of the interpretation. DNA samples that are considered mixtures include DNA from multiple contributors, such as in cases of R. Such mixtures can be complicated to analyze and require specialized techniques and training to interpret these results. The ability to determine the contributors of each individual in a DNA mixture sample accurately remains a challenge, and its impact can be detrimental to case results while also impacting the reliability of DNA evidence in court. Contamination and sample degradation. A significant factor affecting the accuracy and trustworthiness of DNA evidence is its high potential to be contaminated, such as during the collection, the handling, and processing of the samples. Hello, what does Ann Taylor want? That information. The collection, the handling, the processing, the chain of custody. To minimize the risk of contamination, personnel involved in the investigation and handling of the DNA samples need to adhere to rigorous protocols, complete proper training, and adhere to strict chain of custody procedures. To minimize risk of contamination, personnel involved in the investigation and handling of the DNA samples need to adhere to the rigorous protocols, complete proper training, and adhere to strict chain of custody procedures. Chain of custody procedures. Contamination can occur in many forms, not only from individuals handling the samples, but also from external sources. For example, crime scenes that are outdoors are exposed to nature, casual individuals, and the weather, possibly contaminating DNA evidence prior to crime investigators being able to preserve and collect the samples. Mark Carver. Due to exposure to environmental conditions, a study by Dutta emphasized the importance of assessing the degradation degree of DNA samples collected before analysis. Now, I'm going to get into another interesting part of this article here. False positives and false negatives in a forensic DNA testing can be due to several factors, such as errors in sample handling or test interpretation. A false positive occurs when a DNA profile is incorrectly determined to be a match, which leads to a false accusation of an innocent individual. A false negative arises when a true match is deemed inconclusive or inaccurate, which can cause a guilty individual to walk free of any criminal charges. Some of the factors that contribute to the occurrence of false positives and false negatives include technical errors, sample contamination, and challenges in interpretation. To reduce the risk of such errors, there needs to be a continuous research to understand these factors and improve laboratory procedures and protocols in DNA sample handling and analysis. The statistical analysis of DNA evidence plays a crucial role in interpreting these results. Estimating a match probability or likelihood ratio is a fundamental component of DNA profiling. However, the accuracy of these statistical calculations depends on the underlying assumptions and available population databases. An article by Bright in 2002 highlighted the need for comprehensive databases that accurately represent the relevant populations to avoid potential bias and inaccuracies in calculating match probabilities. Expert testimony and admissibility in court. After collecting, handling, and analyzing the DNA samples, the results must be presented in court. This is when the accuracy and reliability of DNA evidence impact its admissibility and weight in court and in given expert testimony. Emphasis is placed on the importance of ensuring proper validation in peer-reviewed methods in forensic DNA analysis to ensure this occurs. DNA analysis is subjected to scrutiny regarding its accuracy, reliability, and potential limitations, which is why legal systems require robust scientific evidence to support expert claims. Which is why legal systems require robust scientific evidence to support expert claims. To avoid misconceptions and to ensure fairness during trial, experts need to be able to effectively communicate the limitations of DNA evidence to the courts. Undoubtedly, DNA evidence has revolutionized forensic science and continues to have a significant impact on criminal investigations. However, its accuracy is not infallible, and several factors can affect the reliability of DNA analysis. As mentioned in the article, factors such as interpretation challenges, sample contamination, and misconceptions in court can all contribute to the complexity surrounding DNA evidence. Although there may be doubts surrounding the accuracy and reliability of DNA evidence, there is ongoing research and development to negate these doubts. In addition, implementing rigorous quality control measures, validation studies, and population databases can also improve the accuracy of statistical calculations. Proper training and education of forensic scientists and effective communication of limitations by expert witnesses are vital in ensuring fair trials are conducted and proper use of DNA evidence occurs. A strict chain of custody. Here's all the sources on this article. A strict chain of custody. Good evening, everybody. Thank you for hopping in. I just wanted to play that real quick as we started off the show tonight. I thought it was something that needed to be played again. Drop the link for the article in chat. What's up, everybody? Yeah, that was a highlight I made from the show earlier. I thought, why not just go ahead and replay what I read earlier? Yes, we do that from time to time, Tiffany. What's up, Root? How you doing? What's up, Unravel?
Hey,
Yolie, you have one as well. Good. What's this? What's up, everybody? Thank you, Nina. Thank you. What's up, Convict? AR Hayes. What's this video that Detective Golden was talking about here? We need to watch the video of the night of the crime that you enhanced Unravel. What's up? Do you have it uploaded on your channel?
Yes.
Yes, you do. Okay, give me 1 second. I'm going to drop her link in chat as well. If you're not subbed, I'm sure you are, but if you're not, she does a lot of good videos. So let me see here. Thank you again for hopping up. Sorry to hear about the delays, Yolie. I know that can be frustrating. You were ready for it to go. I'd like to hear what she has to say about that article, too. All right, so let me see here. We'll get... There she is. What's up, Yolie?
Hi.
Hi.
Sorry to hear about that. I know it can be frustrating. You're ready to go, 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 and then... What's up, typically?
Can you hear me?
Yeah, we can hear you. Can you hear us?
All right. Yeah, it's very frustrating, but oh well.
Yeah, I can imagine. You spend all that time getting prepared, and then you have to do it all over again. So when is it now?
January 26th, and we don't even know if it's going to go forward, but
Oh, really?
things are going to
What
change.
happened?
Yeah,
What
things are
happened
going to
this time?
change because experts they're not going to want to put aside time and block out a time and then lose patients, and then patients that are scheduled to see them, and then just to be told, oh, it's not going, so they have that whole day vacant.
Mhm.
I mean, I foresee these
Yeah.
experts billing the courts saying, hey, pay us, because we
Yeah,
can't get
because
shit
they
done.
run a business too, and times are tough right now, especially economically. And if
Yeah,
you lose a whole day of business, that can, yeah, people don't
yeah,
have, especially even with the way shortages are now at businesses, people don't have the opportunity to just be like, okay, at the drop of a hat and be ready to go for as long, you're right. So
yeah.
hopefully, is that going to affect any of the people that were going to be there for this trial? Is that going to...
Yeah, I mean, we have oral surgeons and dentists, and they have patients. They make a lot of money, and so they reserve dates and they're canceled. But luckily, the two that I have, the two experts, they're able to recoup. But in other cases, I've heard, they have neurosurgeons, they have orthopedic surgeons who make a lot of money, and they reserve, you get a trial date and they reserve the estimated date. They send them a trial subpoena with an on-call letter so that they're on call, and they block that time out. And so when you go to court and the court tells you on the date of trial you're not going to go forward, then we tell the experts they're shit out of luck. I mean,
Right.
they got to reschedule everybody and try to make up for it. But I
Mhm.
foresee that something is going to change. But anyway,
Mm.
I'm free.
Yeah, well, we were happy because, everybody's been asking about you, and I'm like,
Oh,
she's getting ready for this. I was shocked that you actually hung out as long with us as you did on panel because it was like a couple days before. I'm like, damn, well, thank you so much. I was so
well,
appreciative of
keep
it.
in mind I prepared for this trial like two or three times before. So this time was really intense, and we even got the blow ups and everything done. And no, so the next time it's not going to be. I mean, I haven't memorized, so I have the cross examination for everybody. I have the direct for everybody. So it's just a matter of doing it, you know?
Yeah. Well, I'm glad you're here with us tonight. It was kind of when I got that email from you earlier, I was like, yeah, even though,
Yeah.
it can be frustrating, I was like, yes, yes. And then I knew Un-rav-el. Sorry I wasn't on last night, Un-rav-el. The show just, we waited forever and forever and forever for that court hearing. And I still had a lot of other stuff I had to do, and some stuff I had to push till today just because I wasn't even able to do it because of having it drug out. So I apologize about not being on last night, but we're here tonight, and I'm like, hey, we're late nighting. We're nighting the true crime tonight. I made a special thumbnail for it, so we're gonna be here. I sent you the documents, Yolie, that I just
Okay.
read, or the article. I'm sorry, that I just read. Did you get to hear any of the document? What'd you think of it if you did? And would you be interested in reading it and telling us what your thoughts are when it comes to?
Yeah, I mean, you read it. Let's see.
I read it this morning.
The point is, it's not reliable.
That's what I'm saying. Like, it's so important. I wanted to repeat it because, there's a lot of talk about, well, why, when we watched the court hearing, she was like, I just want the handling. I want,
There's nothing
basically the chain of
unreasonable.
custody. You know what I'm saying? And that's very important. And that's why I replayed this article that I read because it's very important of the chain of custody because of what can take place with what was in the article. And you should, if anything, be able to provide a chain of custody. There should, like, that should be homework page 1.
Well,
Chain of custody. You know what I'm saying?
like I said, when small towns ask for assistance from the state police or the FBI, those agencies step into the shoes of local law enforcement. And so there is a Department of Justice, I guess there's a manual, I guess, or some kind of instructions that says how they're supposed to do things. And
Mm-hmm.
so
Rigorous,
that's what Ann Taylor was referencing. And the fact
Why
that they
wouldn't you?
don't do it doesn't absolve the prosecutor from saying, oh, well, some other agency did it.
Yeah.
I don't have it. No.
You should have the chain of custody.
Yeah.
You know what I mean? Like, there
Yeah.
should be,
And so,
and this is,
go ahead.
well, this is what I don't understand is he also stated in that court hearing that he supplied okay, so it went from the ISP to Orthram, the private lab, before it went to the FBI. Now, he states in the court hearing that he sent the documentation, or the Orthram sent the documentation to the FBI and also to the ISP.
Mm-hmm.
So why wouldn't the ISP even have the chain of custody? That I don't understand why it doesn't. Okay, so it went to another agency.
Doesn't matter.
Right? Where's the chain of custody up into the other agency?
Yeah, it really doesn't matter because the other agencies stepped in, and this is the only way that I can explain it. The other agencies stepped in the shoes of local law enforcement. They assisted in the investigation, they interviewed witnesses, they
Yeah.
did what local law enforcement would do if they had the manpower to do it.
Right. Yeah.
So they cannot hide what they did because they're another agency. That is a violation of the civil rights of a person who's been charged. The other thing is for Mr. Thompson to say, well, we turned over the order. We asked the FBI for this, and we did it on Monday. And then guess what? Tuesday and Wednesday, the FBI is out there at the house.
Mm-hmm.
I'm sorry. I mean, I wasn't born yesterday. I mean,
They all think we do.
I mean, I may look like I was born yesterday, but I wasn't.
They all think we were.
No, I wasn't born yesterday, and to the excuse that they give that it's because they wanted to do a reconstruction of the home of the inside for the jury. Bullshit. They were there for 2 days. Okay. They could have done that before.
Right?
How
You could have done that since December, right?
I mean,
Hell, January.
February. I mean,
Right, after the holidays.
they're being pressed. They're being pressed by the judge because the judge is saying, yeah, you can't bullshit me with this jurisdictional shit. Okay. You can't tell me that, oh, the FBI has it. That's federal. You know, you don't have jurisdiction over the federal. I don't have jurisdiction over the federal. Guess what? No, they stepped into the shoes of local law enforcement, and it's all in the Department of Justice paperwork, the guidelines. I don't have.
Yeah, they did. He did reference Department of Justice in the court hearing as well. Yes.
Yes, it's all in there. And I remember
Yeah.
reading it. I remember thinking, these guys are fucked. You know, I'm sorry.
They're
And
not
you
going
know-
to get the information, are they?
I'm sorry?
I was saying earlier that the trial's going to get. It's going to go to December 1st, then it's going to get delayed to early January, then it's going to get delayed again till early February, and that's when the court's going to go. We're not going to get the paperwork, everybody. We have to move on.
Yeah.
Because I don't think they're going to give it to them.
Well, the trial hasn't been set, but the date by which the FBI has to give that information to the defense.
But you can't give a date to them, can you? Because it's up to them whether they want to give it to you or not. And that's what I mean. There really is no date. Bill Thompson 2 months ago was already saying he was going to reach out to Orthram to get paperwork, and he still said the same shit yesterday, like he never reached out to him. You know, they don't care to get it because they're not going to use it. And he can there is no date for the FBI because they can just simply not give it to you if they don't want to give it to you. And so it's just going to keep getting delayed.
Well, in civil cases, when I bring a discovery motion and they're not giving it, and the judge says you have to give it by this date, and by the way, you're sanctioned so much money because plaintiff's counsel had to bring this motion. And what we do is we prepare a declaration of how long it took to prepare the motion to compel. And the judge will say, that's a sanction. You pay plaintiff's counsel for the amount of time that it took for her to prepare this motion, for me to give the order for you to give it. And I don't know how criminal law works, and I don't know why, you know, I guess the motions are for supplemental responses. I'm not sure. The procedure, I don't know. But in civil, they would definitely be sanctioned because I would definitely put a declaration saying, look, this is how much time it took me to bring to the court's attention that I'm entitled to this. The court has ruled that I'm entitled to this. So all this time, you, defendant, have to pay me. Or you, prosecution, have to pay me. So I don't know how it is in Idaho. Everybody was so relaxed. Everybody was so patient. And believe me, I saw parts of it, and it's frustrating because that's how it is in my case. Everybody's so relaxed and, well, you know, we don't have courtrooms. It's like, excuse me, we're ready. I'm ready. Defense counsel's ready. Why isn't the court ready?
Right.
Give me
Right.
some
Right.
kind of reason. The court's not ready because they closed down everything in COVID. They didn't have a plan. I get it. And criminal cases have to go first. I get it. But where does that leave us? Where does that leave the plaintiff? Where does that leave me? I mean, I have to make a living. I have to do trials in order to get paid. I have to do trials and win. So when I look at Ann Taylor and I look at what she's asking for, it's not unreasonable, but I don't know the procedure. I don't know how it works, in terms of asking for.
Well, and this is my point. They're this whole time they've been avoiding, because one of the reasons Ann Taylor has 9 supplemental requests for discovery is for this information. And they continue legally to drag it out because they're not going to offer it. They're basically, they've been at a point since like number 3 or 4 that they're basically telling you in different ways ever since, we don't have the information because an agency above us has it. We simply can't supply it if we don't have it. And what I'm thinking is that he can tell you a month because he's got to give you some kind of deadline. If not, the judge is going to set a deadline, and all he can do is say, I'm going to try, which is what he did. At the end of the court hearing, he made this little stance like, and I'm going to reach out to them and I'm going to let them know that there's an urgency in time and da 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 da.
Yeah, and how
But
long?
that's all PR. That's
Well,
all
that
PR.
should have been the DOJ policy should have been followed from day one. There should
If
be
they don't want to
no.
offer it, if they don't want to offer what Bill Thompson is claiming he can't offer because another agency has the information that the defense is asking for, then he just simply can't offer it. And I think the court's going to get to a point where they're delayed so many times, they're just going to have to move on with it without
Well,
it. You
there's
know what I mean?
always there's always the motion that he hasn't ruled on, which is the motion to dismiss based on prosecutorial misconduct and all that, and the bias of the grand jury. So that hasn't been ruled upon. That was the closed. It was closed to the public. That hasn't been ruled on.
Right.
So a lot of this DNA shit has to do with that.
Oh, he obviously don't know. He's so confused. You could tell.
Oh, you know what? That's why I said, look, if I were a judge and they brought this probable cause declaration to me, if it excluded all the DNA stuff, just with the cars and the pings, I would say, I need more. But once they include the DNA shit, I can't question that. I have to say, okay, you're putting in a declaration. I assume, you have what you say you have because you have to, and there's probable cause. But now, when they can't produce the goods, it's like, okay.
Yeah.
And you're saying that this DNA had nothing, this touch DNA had nothing to do with the probable cause, yet it is in the probable cause affidavit. And that's, in my opinion, if I were the judge, that would have been the key factor. If they can't show the goods, well, guess what? I'm sorry.
Well, it's like this. He was one of the 22,000 possibilities, just like the Oregon car. And when the Oregon car went bust, they probably handed them a tip and said, here's a name that we've came up with. It's a little piece. It's not the whole thing. And because the Oregon car went bust, they just went boom, right to it. And I think they just went off the tip. I don't even think they saw the homework. I don't even think they were given the homework. I think the tip was just a minimal kind of tip, like, hey, here's a direction you can look for. Not necessarily, I don't know. I have to question that with the way that it was jumped on so quick. And I think the whole thought process from the beginning was enrollment, because their funding even depends on the enrollment, everybody. And look at all the funding that they have going into that department. Their funding depends on the enrollment as well. Their funding depends on the enrollment, not even directly, but also secondary, because the funding from the enrollment also funds the other local businesses, which also funds the department.
Yes.
Very important about enrollment in so many different ways when you're talking business.
Yes.
They depend on the community to fund them. Who funds the community? The students, the
Well,
university.
yes. And I do know about that. I mean, I'm not here speaking out of my own, like, I'm not talking shit. I have experience with that. I've had experience with the UC Regents, huge case. And yes, it is about enrollment, especially if you have a medical school associated with it. It's even worse. It's, I mean, it, you know, I have that experience. I don't wish to comment on it, but people can look me up if they want. But hey, I know about it. I know about it, and I know even criminal activities that take place in a university will be covered up. They'll be covered up because of money
I
and
mean,
enrollment.
Kara's mom's or Xana's mom, Kara's even saying that nobody's talking. Steve G's trying to reach out
Oh,
to people, and that's when he was told he needed to slow down. Because he was getting too close, and they needed to. We have to dot our I's and cross our T's, and we're on the same track, but you're ahead of us, and we need to.
those families, they just need to be
It's like,
protected. They just need to be like, please, like, just give them a big hug and just hope that everything goes well, and the people that are in charge of doing what they need to do it. I mean,
yeah,
these,
the right person gets convicted.
and I said from the very first time I called in, I said, there's a lot going on. There's drug addiction, there's post traumatic stress disorder, there's, there's a lot of students who have problems with their families. I mean, this is like who knows? BK may have had problems, like he may have. I mean, who knows? I don't know. He may have been looking for medication when he was driving around there. I mean, I don't know. He was previous history of H, but we don't know if that's true. But I mean, this is
Well,
just
think about it. He was under a lot of pressure, right? And
absolutely.
if you have a prior addiction, maybe one of the things that you do is clean at night because you want to keep your mind busy, because you don't want to distract it with thoughts of, because it was getting towards the end of the semester. He was having people sitting down talking to him because of his grading the other students. There was a lot of pressure, and maybe he was just either cleaning late to, hey, I need to keep my mind busy so I'm not distracted with thoughts of something else. I need to drive around so I'm not distracted with thoughts of something else. You know
And
what I mean?
as far as him being harsher on the women and all this shit, being an asshole to women, well, guess what? The majority of men are assholes to women. Okay? I get it all the time. Do I take it personal? No. I
It's a
just say
joke.
fuck you and
Right.
do what you want. It's not.
That's why we love you. You're spunk. I just
It's
say fuck
not.
you.
It's not some. Guys can be jerks. Yes, they can. And you know what? If you're gonna take it personal and doubt yourself, well, you shouldn't.
No. No. Well, Un-rav-el, are you still there?
She's here.
Would you guys? I mean,
I am.
the court hearing's only like maybe 26 minutes or something. Would you guys like to watch it again? And if you want to talk about some part of it, I can pause it and we can kind of discuss it just for a little bit, and then maybe go into some of your videos. Un-rav-el. You guys have time for that?
I do.
Sure do.
Okay.
So Medicated is saying that he's guilty. What
I
are
don't
you
know.
guilty of?
I don't know. I wish I was at the water cooler for real, because I would like to be able to tell you everything that I would like to be able to. I wish I was at the water cooler.
No, I mean he's saying he's guilty of being a jerk, probably.
I don't know. I
I
have
don't
no
know if
idea.
it's
I
he or
wasn't
she.
at the bar. I wasn't at the bar with him. I don't know.
Anyway, my point is that you
I don't
can't.
know.
I mean,
I wasn't at the bar. I don't know. I wasn't.
I know. But
Were any of us?
even if I was, would I? It's happened to me. I mean,
I don't know. I can tell you I wasn't there. So that's all I know. I wasn't there, so I can't tell you if he was an asshole or not.
all right.
No idea.
All right,
Uh,
so yeah, I have time to watch the court hearing. I watched parts of it, but not all of it. And then I would like to watch Unravels,
yeah.
the videos.
Yeah. Something about Detective Golden said. What video was Detective Golden talk about, Unravel? Which one?
I don't know.
You don't know? Detective, what video from Unravels were you talking about a little bit ago when we started the show? All right, let me go to the court hearing here. And really, anytime you guys want me to pause it, when you want to discuss something about what's said, just let me know. I'll go ahead and pause it. We can rewind it. We can do whatever. I'm going to turn the music down because the audio is kind of shitty. You know how it is in the Idaho courts there. It's always something.
Detective Golden said it's the night at the Banfield. That was the one with all the where people saw 4 and some people saw 5 people.
Yeah, it's probably the latest one.
Yes.
Okay. Night at the Banfield. All right. We will go to that after we are done discussing this latest court hearing. Thank you all. And if you guys want to discuss something too in chat, let us know.
All right.
So let's get on the record, please. Okay, we are now on the record. This is State of Idaho versus Brian Koberger, case number CR 2805. We're conducting this status conference over Zoom. There are people in the courtroom, but all counsel are participating on Zoom. Representing the state is Ms. Jennings, Mr. Thompson, Mr. Nye, and Ms. Beatty. Representing Mr. Koberger is Ms. Taylor, Ms. Massa, and I don't see Mr. Logston, so apparently he's not here. I believe that Mr. Koberger is also on Zoom. Is that right, Ms. Taylor?
Your Honor, he is. We're in the same room, and you can't see him, but you can hear him, and he can hear you.
Okay, great. Okay, so you are downstairs right now.
I'm downstairs.
Okay, this is one thing that I didn't understand. I'd like to hear what you guys think. So I understand that this hearing was what the judge was supposed to get to see all of the IGG information, and he was supposed to determine what the defense was going to see. Now, I don't know if this is some kind of COVID measure. I assume not, because they're not wearing masks in the courtroom. I assume this has to do because the defense has to either be muted or screen covered for the judge to then determine at the court hearing which evidence they are going to be able to see and hear. So I believe that's why they are having a Zoom court hearing for the defense's side, because they have to be screen covered and muted while he determines what is they're available to see from the prosecution. What I don't understand is why Bill Thompson was also on a Zoom. Wouldn't you think that he would have to be there in person?
No.
No?
No.
So he could
He
But
knows
but
everything.
but why wouldn't he? Because I can see why the defense would, because they have to be, he's got the prosecution's going in there. Here you go, judge. Here you go, judge. Here you go, judge. And each time, here you go, judge, he then determines, okay, the defense can see this or can't. So then, okay, if they can, all right, hey, everybody, defense, boom, screen cover gone, unmuted. Here's the evidence of this part of the IGG. Now we're moving to the next part, screen cover muted. That makes it to where he can determine what they can see, because that's the point of the hearing. I don't understand why Bill Thompson wasn't there.
Convenience.
Well, I can explain that if you want.
Yeah, go ahead. Because I don't know. It just didn't make sense. I mean, okay, yeah, because the defense is too, but I see why the defense is having to do it, because of having to be on that side where they're being determined if they can see something you're not presenting it in court. But why the prosecution? I don't know. I just thought maybe it is nothing. Maybe it was just out of convenience. 100%.
Yeah, so technically nobody has to be there. The only thing that has to be there is the information
No,
that the judge wants to review. So
yeah, I'm not saying that's not it. Yeah, it's not even that in depth of what I'm asking. I'm asking, like, why wouldn't he have just been there? I know it's about the evidence. It always is in court.
Yeah, he doesn't need to be there.
That's
No.
an obvious,
Yeah.
Yeah, I know he doesn't need to. It was
So that's
just,
why they're on Zoom.
I don't know. It was just
That's why they're on Zoom.
a general.
Because the prosecution has already provided whatever it is that they want the court to review, which is nothing basically, unless so the court reviews it in chambers. That's what typically an in-camera hearing is. He doesn't review it out in open court, so he can review it in chambers and then issue a ruling on what the defense is allowed to see and what is withheld. And so
basically out of convenience
yeah,
is what you're saying. Basically is just convenience.
it's convenience, and it's just not necessary for you to be there.
Yeah, I know they do it all the time. This is the first one.
Yeah. So then the judge will issue a ruling as to what he thinks the defense needs to see. But it would have already been decided before they even hit live on the courtroom feed. It would have already been decided. Yes, possibly. Unless at the time of the hearing they were just given the information, and on the live he just got it and he has to review it. But
it didn't look like he reviewed it during the court hearing. It looked like he was more curious about what the two SMPs meant, and wondering when the documentation was coming in, because Ann Taylor, I thought, did a great job displaying patience when it comes to everything that she's asked for, and the fact that she's still not getting it. And I think that's going to win some of the jury, because this right here, even if it is on a Zoom, she was displaying a lot of patience in this court hearing, because it is ridiculous. Like, when you look into the DNA and what you should have, especially when you're trying to, let's be honest, there is no picture. The cell phone data could be anybody, because you're utilizing the same tower. And so what, he shut off his phone a bit before and a long while after the crime took place. He was one of the 22,000 leads after it became a white vehicle. And they just had, they just had a little tip real quick. I mean, and just because the sheath was there doesn't mean that's what was used to commit the crime.
No, but yeah, so going back to this in-camera hearing, the defense, the prosecution, Mr. Thompson, I saw bits and pieces where he was saying, I don't want to promise. I mean, I can ask, but it's like he already knows they don't have it. That's the impression I got. Like he's like, well, I'm going to ask for it, but I can't, it's like he already knows they don't have
Yeah.
what they need.
That's why he's been saying that. He's been telling them in different ways the whole time.
But with the FBI, it's a different process.
Well, it's governed by the Department of Justice rules, and that's why Ann Taylor attached the Department of Justice when local law enforcement ask for assistance from the state police or the FBI. You got to have a procedure, because it can't be, a criminal can't be, held, and the FBI say, well, and the state say, well, we don't have it because the FBI has it. That's not how it works. If the FBI investigated and was a part of the investigation, they stepped into the shoes of local law enforcement. And so my understanding is that there are Department of Justice rules that govern this. And she attached those rules. And I remember looking at them on a motion. And I remember thinking they didn't comply. If they did, they would have it. So the point I'm trying to make is that at some point, the judge has to make a ruling. Like, he does agree that they're entitled to some of the IGG stuff at least, but he needs to see it. If he can't see anything, then what does that leave him with?
This is what I'm afraid. I'm afraid two things. I'm afraid that the judge doesn't really understand it, and I'm afraid, and this is why I say it's so important that we talk about this DNA stuff being a possibility, because I don't think the juror members are going to know that much about it either. And when you're talking about potential juror members, they could be watching these shows right now. And so it's important for us, as much as we talk about guilt or innocence on here, on these YouTube shows, it's also important that we talk about different things that can happen, especially when it comes to some of the most confusing stuff in this case.
So I learned, and basically being on panel, we all learned that this genealogy thing, it's a tool. It's an investigative tool. It's similar, it's similar to a polygraph. So it's used to exclude or include suspects. It's not used to indict people. Okay. So like a polygraph is not admissible in court. But the defense, if they're going to put he failed a polygraph in the probable cause affidavit, then the defense should be able to discover the qualifications of the polygraph person that did it, the way it was done, what time it was done, the circumstances surrounding it. Was, for example, was he a diabetic and he hadn't had food, and maybe there's all kinds of things that could interfere with the heart rate. And
because there was syringes. You even mentioned that in the PA search warrant. You mentioned the syringes and stuff too. So who knows?
These are all things that are discoverable. Now, the only reason why they're discoverable is because you got to figure things out. If you could find admissible evidence based on this information, then you get the admissible evidence. So the same thing with IGG. It's a tool. It may not be admissible in court. I mean, it may not be. And the only people who are going to hear it are the grand jury. Okay? Not the real jury, but the grand jury. And so if the defense isn't allowed to be at the grand jury, proceedings, which they're not, then if 6 grand jurors have questions, the issue remains, what's in the transcript? What did the prosecution tell those 6 jurors? Like, I don't know. And see, nobody knows, because that's in the transcript. So this guy,
I think they wanted the photo. They wanted the photo of the car.
Yeah, I don't know. Probably, but
I think that's what they wanted. Because
maybe they also wanted information on the DNA.
well, I mean, that would be a lot of explanation, and you would just assume they have that locked down, and you're going to learn that in trial. That's because I first thought that, and then I'm like, well,
admissible at trial.
I think it was as simple as just wanting a photo with a car because they were probably not even given video. They were just given basically the PCA. I think they just, right, because it's probable cause. That's all they needed, and I think they just walked in with the PCA, said, "Here you go." And then the one question that they wanted for more evidence looking at the PCA was, okay, well, we get the cell phones, we get the we get all this, but where's the photo of the picture, where's the photo of the car, because we still have the stock photo. And if you have him going all over here, you should have a photo, something, even if it's grainy.
But the grand jury has to hear evidence. It has to hear admissible evidence.
Isn't that the photo of the vehicle? They claim to have all this video surveillance in the PCA.
Yeah.
They claim to have all this video surveillance. They claim to know the route and when Kohberger went there. So you have it locked down, all of the surveillance, and you have it locked down of the path. So how come you can't supply a photo of the vehicle other than the stock photo? And I think that it's that simple. That would have been admissible. It should have been provided to the grand jury, right?
Yes.
And I think that is one of the main things that anybody is going to want to see in this trial is a fucking photo of this car.
Yes.
And I think it's that simple. They went in with the PCA expecting the grand jury to be like, okay.
Different.
No, but this is the grand jury, the secret grand jury that they held, and they went in there and they said, here's the PCA.
I had the photo.
Yeah. See, you can't have a grand jury indictment.
You can't get a photo yourself?
See, here's the issue. Here's the issue is that you can't have it both ways. You can't ask the FBI to get involved and then say
they were the ones.
They have the photo. We're going to arrest them. We're going to hold them in jail. And then when it comes to the grand jury to say, well, we don't have it. The FBI has it. Well, guess what? The judge ruled that if the FBI has it and they were involved in the investigation, then that means the prosecution has it. So
they're the ones that ID'd. They're the ones that the FBI is the one. The FBI is the one who came to the conclusion it was a 2011 to 2003 Hyundai Elantra.
The judge said that. He said,
"Yeah,
so."
You're saying MPD couldn't get a photo themselves to put out to the community because the FBI is the one?
That's not what I said. That's not what I said.
I mean, no, I'm not saying you said that. It's a question. Like
the judge did say that the FBI was involved in the investigation.
Yeah. Well,
I understand that, but the FBI,
the prosecution admitted it and said that they found that the FBI was the one that came out with the description of the Elantra. They said that, and then it also came out with an updated from a 2011 to a 2013, then changed to a 2011 to a 2016, based off of the same agency that came up with the tip in the first place about the vehicle. So Moscow didn't come up with the vehicle either. And I think that's why they didn't put out another photo, because I think they literally just had the surveillance of all these white cars or light colored vehicles driving around. They had 22,000 tips. One of them was gone because Oregon went bust. And then they were just handed a little nugget and frickin' ran with it. That's why they didn't offer a stock photo. That's why they don't have a stock photo, because they didn't even do the homework there either. They just ran with it. Well, they left it up to everybody else to do it.
The one thing that I will say is that when it comes to being an attorney or prosecutor or defense attorney or civil attorney, there are certain things that inherently the attorney representing somebody has to have access to. So the judge in this case said, and if Scott Reich talked about it, that, yeah, you know, if you have outside agencies that participate in the investigation, that do things and collect evidence and interview witnesses, you know, they step into the shoes of local law enforcement. And that's why the Department of Justice has these guidelines. And gosh, I wish I had them, but Ann Taylor, she attached them to her motions, and I saw them and I thought, oh, I see. And so it is presumed under the law that if local law enforcement are going to use higher ups, state police, FBI, they have to comply with the rules just like the local law enforcement have to.
No.
But they don't have to offer the information. That's why it's going to keep getting delayed. That's why they never got it.
Well, the
And
judge
prosecution's not
the
worried
judge
about
said
it.
that they do have to.
But Yolie, they can gaslight like a motherfucker, can they
course.
not?
Yes.
And that's what they're going to do. Because that's what I'm saying. If 2 months ago, when Bill Thompson was holding his frickin' notebook in his hand and he was like, Your Honor, we're going to reach out to that private lab and we're going to see what we can get. We're not sure, you know, it does take a long time, yada, yada. That's the last we heard of it until today. And then he says the same shit that he said 2 months ago. He doesn't care.
No.
He don't care. And there's no urgency for it. He knows they didn't do the homework. He already knows that they can't offer the homework. And he already knows, just as he referenced to a prior case where they were not having to supply information because a higher agency had it. Same thing, and he's going to continue to roll with it in this case. Look, everybody, just like grand jury, asking for more evidence, which I think it was the photo of the vehicle. And they said, look, this is everything. This is probable cause. Trust us. And they said, okay.
It's possible. Well, it's also
Okay.
possible that the grand jury wanted to hear from Bethany Funk or Dylan Mortensen, because I don't know that they testified.
Oh, yeah, of course. All that's possible. Just
All of that.
like it could have been the DNA stuff. I just think it was as simple as asking for a photo of the car, because if you're walking in there with the PCA, because that's all you need, where's the car? Go ahead, Un-rav-el. I'm sorry.
No, I'm sorry. I just sent you something to explain better.
What is this? Practice tips? Let me see. Open.
With regard to typically unique's question, the grand jury does not have defense counsel there. Preliminary hearing does have defense counsel and prosecution there. So at a preliminary hearing, defense counsel can object to evidence. At the grand jury, no. The defense isn't there.
Turn the music back up. What's this article? What's the article, Un-rav-el?
It's when it receives a subpoena. The FBI receives a subpoena.
But they don't have to. They can simply say it's part of a bigger investigation and there's nothing that they can do about it. And then the court would have to move on, right? You can only delay it so many times while you're waiting.
In this case, there's a court order, not a
It's a
subpoena.
process.
What's that?
And this is for use in civil proceedings, okay? So obtaining potentially important evidence from the FBI for use in civil proceedings. This is not a civil proceeding. This is a criminal proceeding. And not only that, but it's not a subpoena for information. It's a court order. The court ordered the prosecution. It found that the prosecution inherently has access to the FBI information because the FBI stepped in the shoes of local law enforcement. Now, if the FBI doesn't have it, that's another thing. But the trial court, Judge said, look, they participated in the investigation. They interviewed witnesses. They gave a tip They set up a tip. I mean, they actually set up the tip line. They actually were monitoring BK in Pennsylvania. They took the trash from the neighbor of BK's family's home, and they got a SWAT team to go over there and get them. They participated, and that's not a civil proceeding, that's a criminal proceeding. So getting Uncle Sam to talk and obtaining potentially, whatever information in a civil proceeding is very different than getting them to give information in a criminal proceeding.
Typically, Unique has a question for you too, Yolie. Why would a prosecutor decide to go grand jury instead of preliminary hearing? What are reasons for doing it? I think it's to suppress evidence, no?
I'm not a prosecutor, so I really can't answer that question. And I'm not familiar with the grand jury proceedings. I'm not familiar with preliminary hearing proceedings. But what I do know is a preliminary hearing is similar to a motion for summary judgment in a civil case. So in a civil case, when somebody brings a motion for summary judgment, they're bringing their expert and they're saying, hey, this is why you don't have a case. The expert says such and such and such. Then I have to get my expert to bring a declaration that says we do have a case because such and such and such. So there's a triable issue of fact. So the preliminary hearing is trying to find if there is a triable issue of fact for a jury to find beyond a reasonable doubt that this guy committed the crime. That means, does it go forward? And that's the same thing as a motion for summary judgment. Does the case go forward or does it get dumped there?
Yeah, it's going to, in my opinion, it's going to continue to get delayed until February, until the court says we can't wait any longer and we're just going to have to move on. Then the prosecution's going to go, well, this is what we were telling you from the beginning. We weren't using this anyway. We have all this other evidence. We got the cell phone pings. We have the surveillance of the vehicle.
Yeah.
Okay, but all the
Right.
evidence has to be turned into the U.S. Attorney or Department of Justice official who will determine whether or not prosecution or further action is warranted.
So it's up to the DOJ to determine what evidence gets released.
Yeah, they have to get all the evidence and then read it over and then okay it or not.
Yeah, Thompson mentioned the DOJ.
Yeah, I don't know.
He mentioned their urgency. They're going to give it to you when they want to give it to you, and they're not if they don't want to. So what's the court supposed to do? They're going to keep going after February.
They're just going to have to wait.
Yeah, they're going to wait until February, and then they're going to be like, all right.
It's what, so
but
we
they
gotta go.
They just might do a dock dump.
I mean, they could. Yeah, I'm just saying realistically, because I'm just looking at the probability of what's going to happen based off of what's taken place so far. And I'm just saying it's going to get delayed a few more times. And then they're just going to say, okay, well, the prosecution's been saying they're not using it. Sorry, we can't get the information from the other agencies because they can't provide it to us. So we're just going to have to move on. What do you think that they would continue to delay, even if it meant 6 months, a year, a year and a half until they get this?
I think they're just going to give it to them as soon as they get it. I don't think it's going to be delayed very much longer.
You think so? You think in a month? So do you think in a month Bill Thompson's going to walk into that courtroom or show up in a Zoom meeting and have the documents provided showing all this information? I don't see it.
Or earlier.
Because why wouldn't they have done it in the last, 11 months?
That's why they went there
12 months. Or 10 months.
Yeah.
No, they went there to do the 3D scan. They didn't go there to do any DNA stuff.
No, I know, but they're going to do it all together. They're going to hand it over. Boom.
They did. Okay, so they did
all of it. You're saying? Okay.
They did go in
my opinion.
Sorry, I don't want to talk.
Okay, that's interesting.
Sorry.
They might. Go ahead, Yolie.
In my opinion, they may have gone in there and they may have done this 3D recreation, whatever, with the couch looking, it's leather, but it looks like corduroy. They did that whole thing. What is it, the Pharaoh?
Yeah, that's the old stuff. They went in there and they saw the pleather turn to corduroy, and they're like, "All right, guys, we got to do this again."
Yeah.
Yeah, exactly.
So they may have done it, but again, when I look at coincidence, I look at this order that the judge on the IGG, and it's telling. It's telling because the judge is saying that the FBI participated in the investigation. So therefore, it is inherently in the prosecution's hands. They have an obligation to ask for it and make sure that it's there, meaning make sure they follow the Department of Justice policies and make sure it's there. So seeing this order, the FBI said, oh shit, let's go take some, do some recreations. Okay, if it took 2 days to do the recreations, the fact that it was on October 2nd, the trial, they could have done that in September. They could have done it in August. They didn't need, and the excuse is that because the trial was delayed, you know, they have time to do it. No, CJ, you said it yourself. Well, what's the timeline? I mean, you'd think they'd be there for months if that were the case.
Whenever their attorney general feels like he can give them the stuff that's accurate.
Well, they had to go back in there. That's the point.
Technically, it was outside.
I don't know if it was outside or inside. I have no idea.
It was outside, but I think the sounds too, or I think they maybe did some sound stuff too from the inside.
Okay. Well, in any event, the FBI went back there after, like a day after, or a couple of days after the judge ordered the FBI to turn over the information on the IGG stuff. So I mean, coincidences happen, and I understand that, but I get a funny feeling about that, and I don't think it's a coincidence. It may be, and it may be there are things that are above my head that I don't know, but I do know that if you have somebody who's arrested and you have other agencies that are involved, like big time in the investigation, the defendant has a right to get that information, and these other agencies and the prosecution, the state prosecution, can't hide behind the fact that, oh, well, the FBI has it. I can't get it. Oh, the Idaho State Police have it. I can't get it. That's bullshit, because the Department of Justice spells out, if you step into the shoes of local law enforcement and they investigate, the defendant has a right to get that information. If it's not there, then guess what? If it's not there, then that's an issue for defense counsel to argue and try to get their client out of jail. That's the very bare minimum that I know.
And she's doing it.
She is. She's a very patient woman. I wouldn't be that patient.
Well, that's what I'm saying. She's displaying great patience in this court hearing.
Absolutely.
You know,
And, it could be because the cameras are on her. Maybe that's it. And maybe I would be like that if the cameras were on me. I don't know, but she is being patient.
Yeah. Okay, let's go ahead. Let's play a little bit of this. That was a great conversation before we even got into it. Is there anything you want to add more, Un-rav-el? Before we get playing?
No, not yet. No.
No? Okay. Thank you, everybody, for
videos.
hopping in. Huh? What's up?
See her videos.
I'm so glad you guys are both here tonight. It's a double bonus. I get Un-rav-el and Yolie with me
Yeah,
tonight. Thank you so much for hanging out tonight, both of you.
the
Appreciate
thing
it.
about Unravel is
I
that she's
love
like,
being here with you guys.
I
well, the
appreciate
thing about Unravel is that she's technologically savvy. Like she'll notice things that we don't notice. That I
Yeah,
would.
she's in depth. She's
Very,
definitely pays attention to the details, you know?
very detailed. Yes, and
Yes.
I'm detailed too, but I'm more of a
I was gonna say
analyzer.
you guys are both.
Well,
Sorry.
It's a good team effort. No,
that
it's a good
whole
team
thing
effort.
about
I
the
agree.
hand movements of um, Brian Koberger and Mr. Thompson. That was a good catch. And the
Yeah.
Freudian slip, that was a good catch by Chief Fry. So those things, those are good catches. I didn't catch the hand movements because it's kind of like mirroring, but I want to see the video of the.
Yeah, did you make that Unravel? Did you make that video of that one court hearing where
She did.
all the you did?
The what one?
Where the hand, you know how you pointed out that they were doing the same hand gestures or something? You made a video where you had it cut down.
I don't know if I actually did anything with it. I might
Okay.
have.
You said that was the most interesting thing.
Yeah, because that was a good catch.
Video.
No, that was a
Aw,
good
thanks.
catch.
You said the most interesting thing was this, and it showed the hand movements.
Yeah. Yeah, let me know because we do have to go to one of the other videos when we're done with this too. So, and we are Night in True Crime. So we're going to go into this court hearing here. We'll probably get 5 or 8 minutes in, and then we'll be discussing some other things because as soon as it's only a 28-minute court hearing, but there's a lot of stuff except for a couple minutes here and there. Thank you all for hanging out. Appreciate you guys for hanging out in chat as well. And we'll look at some of those other videos too after we're done with this. Thank you all for hanging out. Please hit the like if you haven't yet. It's a free way to help. And also sub to Un-rav-el if you're not sub to her channel as well. I'll drop the link here in a second.
Oh, and those pictures too that I sent you in Discord. It shows more of an angle of the house being higher up and how that camera probably would have caught them, because if you look in Discord while this is playing, you'll see what I'm saying.
Okay. Yeah, we can go to Google Earth and look at some pictures and discuss that too.
But that's the Google Earth thing. What I sent you was a
Yeah,
better.
I'm gonna show the pictures too.
Okay.
Yeah, I'm gonna show the pictures and use Google Earth at the same time, and then we can kind of go into that too. Because I do see them right now. It does sit. It is that property is on a slope. You know.
Yeah, and it seems like that maybe it would have caught the audio a little bit better than maybe what we thought originally.
Well, I'm looking at the house. I don't know. Yeah, we'll look at it when we get into it for sure. I got it in my notes after that too. So we'll check out those videos. We'll get into that as well. Yeah, thank you.
It appears that way. So let's get on the record, please.
And everybody, by the way, this is the loudest it can go. You should do an enhanced version, Un-rav-el, of this court hearing.
With the audio?
Yeah.
Okay.
Yeah.
I'll try that.
You should do one. Because it definitely needs it. But yeah, this is the loudest it gets. Let me turn this music down as we get into this. Give me 1 second.
It appears that way. So let's get on the record, please. Okay, we are now on the record. This is State of Idaho versus Brian Koberger, case number CR 2805. We're conducting this status conference over Zoom. There are people in the courtroom, but all counsel are participating on Zoom. Representing the state is Ms. Jennings, Mr. Thompson, Mr. Nye, and Ms. Beatty. Representing Mr. Koberger is Ms. Taylor, Ms. Massa, and I don't see Mr. Logston, so apparently he's not here. I believe that Mr. Koberger is also on Zoom. Is that right, Ms. Taylor?
Your Honor, he is. We're in the same room. You can't see him, but you can hear him and he can hear you.
Okay, great. Okay, so you are downstairs right now.
I'm downstairs right now.
Okay, thank you. All right, so this is a status conference following the court's order addressing IGG DNA and an order for in-camera review. And when we were talking about this at the last hearing, the state wanted to sort of find out how quickly they could get some of this IGG information back to the court so I could review it. So I'll start with you, Mr. Thompson.
Thank you, Your Honor. Well, we met via Zoom or Teams or whatever you call it with the folks from the FBI on Monday, and we had shared with them already a copy of Your Honor's order, and we have now sent a 2E letter, which is the formal request process we have to go through. They indicated that they would try to see if it could be expedited. The 2E letter has to go all the way back to Department of Justice and route through its bureaucracy. We asked for, give us an estimation, and they said, well, it could take as long as a month. And so that's where we are right now. We're already in the process of making sure we've gathered everything from the private contract.
Can I say something real quick?
Company. So
Yeah, of course. Go ahead. What's up?
What I think about this is if the FBI come in and do that doc drop that I think, I mean, they might not, who knows?
I would love for it. That's for sure.
Right. But if they don't and they refuse to do this, that's when I'm going to have questions.
Yeah. I mean, this is where I'm coming from. Look, if the dude's guilty, let me talk about him being guilty as shit, you know?
Yeah, and they
Like,
might
seriously.
do it. Like what?
Like I want something. I want either it's not him or I want it's him. I want something. I want the right
they
person.
have to have a reason why they're. Well, yeah.
I want all this stuff, all this effort to go for the right freaking person that committed this crime.
I completely 100% agree.
I hope they do this. You know what I mean? I hope they do this document drop. I hope that the defense gets everything that they want and we get this trial moving and we all get to know, especially the families, like get to know, like, what the hell?
Me too. I do agree with that. It is going to raise question if they don't, though. Like if
what's your time limit on this document drop taking place? When are you going to get to the point personally where you start to question more? Like where is that point? February, when I'm saying that the defense has to keep moving, or I mean the court has to keep moving because they're not going to be able to have the information still? Is that the period when you'd be like, December, you know what?
No.
Okay.
After December.
After the new year?
No, after the 1st.
After the 1st. Oh wow, pretty quick. Not even a month. Okay.
Well, whenever
why so quick? When it's due, when Bill Thompson's supposed to walk into the court hearing on the 1st.
Yeah, if they don't have it. Yeah.
Really?
Yeah.
I'm surprised. I thought, okay, that's interesting. Why do you feel so strongly then if it's less than a month? Because they were just there a couple of days ago. It ain't been long. Why so strongly? I'm thinking they're going to wait longer.
If they as long as they come through. But no, I don't know. I'm going to question a little bit after when, if it's not, I think they're going to have it though.
I hope.
I hope so too.
You know what I mean? Because I
Yes,
don't want to
I do.
continue to. I don't want
No.
to continue to advocate innocence of somebody that is truly guilty. I just can't continue to advocate guilt when it's innocent until guilty. I just can't continue to advocate guilt. If I was a jury member sitting on that panel, and I'm watching all these shows where we're watching all these expert type testimony videos and all these different things that you would see as a jury member about all the different facts. And I myself, if I'm sitting there, would have a hard time convicting this person. And so that's why I continue to say innocent until proven guilty, because I haven't seen the reasonable doubt go away.
I get that part, and I appreciate. That's why I appreciate you both. I really do, and I love the way that you guys come at it with the way you do, because it really gets me thinking. But honestly, let me think about how I can explain it.
Well, I don't think that anybody here is advocating innocent or guilt. I think we're questioning.
No, not us. I'm not saying
No.
us. I'm saying most of the community. When you look at most of the community, that's what it is. It's 100% guilt. That's why we get ridiculed for saying innocent until proven guilty, because we're not on the gravy train.
And
I actually do think he did it. Don't get me wrong, but I'm not you need more proof.
Yeah. So when people think that well, I'll speak for myself. If people think that I'm not advocating for law enforcement, that's not true. I want to believe that law enforcement did what they need to do, but when I see things that are questionable, I question it. And because there are bad seeds, I mean, that's why I don't believe in defund the police. I believe fund the police so that you can have the resources to weed out these bad seeds. I mean, I applied for law enforcement. I applied for the FBI. There was a serial killer in Texas in the early 90s. And there's a book about it, The Daughters of Juarez. And there was a serial killer that is probably still going on. And I applied under their language thing and I passed everything. But then I was on a waiting list because there was a bombing at the World Trade Center, not 9/11. It was a different bombing. And so I got put on a waiting list and they wanted people who spoke Arabic. So I get it, but I had to take all these tests and the MMPI and all this shit, in addition to the language. So, law enforcement should be screened so you don't have some power hungry, crazy dude on, trying to rule the roost. I mean, you want people who are, I agree with funding law enforcement for that purpose and for other purposes to make sure you have good people in law enforcement and you're not just recruiting people because you need them, because you need a body. And so I am for law enforcement. I'm a lawyer. I'm for law enforcement. But on the other hand, when law enforcement has their own agenda and it's questionable, I question things. It's not to say that I'm accusing anybody.
No, it's the training too. It's the training.
I get that. But when it goes through FBI, the only reason I know a little bit about this part of it is because of the Chris Watts thing and digging deep into that part and how it works a little bit.
We need an episode on that sometime. A Chris Watts episode, members only or something.
Yeah, that one's interesting.
Yeah, I need to cover that case sometime. I never have on my show, even though I was kind of into it while I was just chilling back watching YouTube true crime. Yeah, that's a case I would like to do a show on sometime. I never have.
Yeah. But yeah, I don't want people to think that, like I'm against law enforcement or anything like that.
No,
Yeah.
Well, what do you?
no, I understand when people do that though, because that it does look like it is slightly shady, but when you really start digging into what's going on, you kind of start understanding a little bit more.
Right.
Yeah.
It's like, can you fund the police in a way that it's going to help? like,
Well,
I
everybody has shortages. We even saw that MPD put out a video that had a recruiting video for their own police force. Like everybody has shortages. You mix that with shortages and even proper training. I'm sure a lot of the people that were doing the proper training have retired because when COVID came as well. I mean, how much of the older generation was pushed to early retirement because of COVID? A lot.
oh my God.
And that's why we have a lot of shortage issues, is because a lot of the older generation was filling those gaps. But when they were pushed to early retirement because of COVID, that took out a good chunk of the workforce. Then when you start to come back, yeah, you have a supply chain issue problem. But after that, after time, that ends up, fixing itself. It's like a chain that comes off the gear and you pop it back on and then you're rolling again. Same thing. But not when you ask an entire population to go into early retirement because it was easier for you to do that instead of pay them, or you know
Yeah.
and that goes with the police force too, because think about it, a lot of the older generation, it was all by the books, and as time goes on, just like evolution in a good way, there's also evolution in a negative way, and sometimes those businesses or agencies, not everything's perfect.
Yeah.
And
And
so,
this whole thing about defund the police, it means different things to different people. So it
right.
could mean defund the police. It means change. Like, don't fund the police for these things, fund them for these things. I don't know. But my point is that I am pro law enforcement.
Same here.
I just am against, people's civil rights
The
being violated.
foolery. Yeah,
Yeah,
the
and
foolery.
it's not everywhere. It's not
No.
everywhere. It's certain places where you have people, and it doesn't even have to be race related. I mean, there was an issue with African American cops beating an African American person, like, awful. It has nothing, it has nothing, may not have anything to
No,
do.
I've even highlighted a couple days ago when there was in one of my breaking news segments beginning in a show highlighting a local law enforcement, and I think it was Florida or somewhere around there, that was going door to door before Halloween, double checking to make sure that SOs were where they were supposed to be and they knew not to have their light on for trick or treating. And they had busted like over, I think it said 90 some people that were not registered, or they were not where they were registered at.
Yeah.
I'm going to highlight those things too, but unfortunately we talk true crime. It has nothing to do with race or anything like that either. It has to do with the justice and the truth for the victims and the families and the community, and that's what it's about. So it is about highlighting, because I am pro. Look at me, I got freaking red and blue on my damn shit. I am pro 100%. I'm also pro about truth and justice, and when those two don't mix, then we talk about it.
Yeah.
The fact that you have me up here and we are disagreeing is proof. Just saying.
Of
Right.
course.
Yeah,
I mean,
we explore everything. Like me and
Exactly.
Unravel, we and her can really come to an agreement that we don't agree on a lot of stuff. But
I mean,
that's
it is what it is.
but that's what exploring, and that's where me and Unravel come from, is that she explores my mind and I explore hers too.
well, yeah, like the
It
whole
You have to.
helps all
It's
three of
about
us.
truth. It's about justice. Who says I'm
Yes.
100% right? I'm not.
And me
So I'm
either.
going to explore other things, but you also have, we all know this, and this is why we get the big boot out. Sometimes it's also about respect for the families and the victims and all that stuff. And that's
Right.
why we don't talk about certain things. That's why we don't entertain certain stuff in chat, even because that's what it's about.
Right. And I'm a lawyer, but I'm not a criminal lawyer. So I'm looking at it just, I can talk about the standards of evidence, and that's probably about it. But I wouldn't, I mean, I did get the highest grade in criminal law, and I will send CJ my award for the highest grade. But
Trust me, I have no doubt of that.
that doesn't mean
You're-
anything. I have to practice it in order to be able to be proud of it. But, when it comes to evidence and all of that, yes, I can talk about it. But when it comes to the actual practice, I don't know. But when it comes to evidence and how it's collected and what different agencies are supposed to do, I understand that. But beyond that, like the whole grand jury proceedings, those are things I've never had experience with, and I wish I did. But I can only comment on what I know about. Like,
Well, and I appreciate hey, this is a thought, opinion, and theory show because we're not at the water cooler, so it always is going to be speculation, and I appreciate your contribution to the show with your thoughts, theories, and opinions because that's why I love having you on. That's why everybody in the community loves when you're on, is because they appreciate your thoughts, theories, and opinions. So we appreciate it, even if it is a different kind of system.
and I appreciate Un-rav-el with their detail with the videos and all that. I can't do that. I don't have patience for all
I
that.
appreciate you.
I just learned how to do. I've learned how to get on. I mean, I've learned how to get on panel. I don't know anything.
It's a good mixture. It's a good mixture. That's
I agree.
I love this team up here. I appreciate you two being able to hang out with me tonight.
I appreciate
And I
you
get
guys.
feisty, but it's not against you guys. It's just because.
No.
Oh no, that's what I was trying to
I
tell
never
everybody
take
else.
it like that.
I was trying because I think they were taking it as a different way, and that's what I was trying to tell people. Like, yo, no, Yolie reached out to me before, and she's like, "Look, I don't know if you want to have me up there. I'm gonna be argumentative." And I said,
It's
"No,
gonna take
I want it. I want the fire. I want the fire,
I love
Yolie.
when
I
it's
want
like
the
that.
fire."
Well,
Yes.
it's going to take a few days for me to be back to me, like,
Oh,
Well,
I know.
it
I can
actually
sense
gets me
it tonight
thinking.
too. I was like, I was like, just because this shit got delayed, I could still feel it. I could still feel it. Yeah.
Yeah,
You're good.
it's there.
You're good.
But I'm a
Yeah,
different
you're good.
person. Like, that's why I sent CJ the link for the live stream, because you won't recognize me when I'm there. I'm a different person. But I can switch it off and on. My mind is that way, and normally I'm just very nice. I'm not here to judge anybody. I don't hate anybody. But when
No, I love this place.
things that are awful, like awful things, I've handled awful cases, things that shouldn't happen, and they happen because of political reasons and university reasons, and they want to make it look, they want things to look good, and just put a rose garden in front of the disaster that's happening behind it. I can't, and so
I definitely understand that part, but I really, truly think this is legit.
it is. Yeah, this is because we don't.
As of right now.
Yeah.
It's just my opinion. I
No, I get it. There are people who think that, and if I had to look at my thought process, when I was walking my dog in early January, I was listening to all these podcasts because I couldn't stand mainstream media, and I thought to myself, well, maybe BK was involved, but he wasn't the one that went in there. I start to think that maybe somehow he was involved, but he didn't do the unalivings. So I think too that, perhaps he had some knowledge. I don't know, but the truth is going to come out, I hope. That's all I can hope for.
I hope too, because I hope we have a resolution to this. I hope it's not, a situation where, you read of an acquittal or something. Because I would hate for the families to, to have all this trust and all this time being spent on this one individual, your heart and soul, and the rope of justice you've been trying to reach for the whole time since you found out that these crimes took place. You're not being able to touch that rope that you can see in front of your face for so long, and you're just waiting and waiting until the day that you can finally grab onto it. And then if it comes to a decision where there's no guilt, that's when that rope starts to fade away. You
Yeah.
got so close to reaching it, and now you see it disappearing, and that's what I would hate to see
Ugh,
for
me too.
the
But
families and the community,
And I think
have
that-
I told you what I thought he was gonna actually do in the end?
What do you mean? What do you mean?
When he's pinned and he has no other choice.
What? Who? Pinned and has no other choice.
If
What
he
part
did
of it?
do it, if
Okay.
Ryan did
Are we
do it,
talking in a trial or before?
I don't know when. I just feel
Okay.
like if he feels like he's pinned and he has no other choice, I feel like
Okay.
he's gonna proudly say what happened.
For real.
Yeah.
whether he did it or somebody else did it, he's gonna say what happened.
He's gonna tell it
So-
all. If someone else is him, he's gonna probably watch everybody's expression and like it.
So before the trial even happens, then no?
I don't know when.
What? Like what?
I just ever since this came up.
What like BTK? Like he was
Well-
denying shit, and then he just said, "Boom, here you go, everybody,"
No,
and
no.
just spilled
Well,
it.
with him, kind of.
What? You think
But
so?
I don't think he's gonna say it as fast and like, because BTK was just like like a robot when he did it.
Well, that's how I would imagine. If you're giving me that scenario, that's how I would imagine BK doing it. I
And
mean,
I-
and it would
No,
make
I
sense
think he's gonna
because
be like,
he studied under Ramsland. You know what I'm saying? It would make sense. Like,
well, yeah,
if I'm gonna
but I
if I'm
don't.
gonna wait and
I hate to say this because I do not compare BK with Ted Bundy. I don't like when people do that. It's prejudicial. It's unfair. But Ted Bundy denied everything. But see, he spoke. He didn't keep quiet like BK. Ted Bundy spoke. I had nothing to do with it. He even acted as his own attorney. Okay, I
right,
don't
he
think
represented
BK doing that. So, but at the end of
I
the day,
feel like
Ted Bundy, he I guess confessed, or he basically
Yeah,
let
when
it
he got when he had no choice.
but
But
BK
I
was
think
different because BK is not doing what Ted Bundy did. Ted Bundy was, I mean, he was just a clown. He was in the elevator and he was, I don't know if you guys saw the documentary,
he's
but he
closer
was
to BTK
closer
than he
to
is
BK,
Bundy.
but even worse because he was like, he did want to be the center of attention. He was a narcissist. He did like it. He wanted to cross-examine people. He wanted to be in.
Yeah,
yeah.
that's Bundy. That's Bundy.
Yeah.
I think he's more
But-
like, if he is like anybody, it's more like BTK,
Yeah.
where like she's saying the situation where he's going to continue to
I
deny
don't
committing
know.
the crime, and then he's going to be backed into a corner, and then it's just going to come spilling out, right?
But he's gonna do it arrogantly.
That's what-
I think he's
Arrogant.
like,
He would have
Yeah.
already shown signs of it, I think, but I don't know.
I don't know. Let's see. I don't know either. Really, I'm just throwing.
Wouldn't he
just
have
what-
taken the? Okay, but
No.
when they threw if he
wants
did
to
commit
play?
the
He
crime,
wants to.
he wouldn't have changed his tactic after the death penalty and then came up with a plea. You think that he's
There's-
just going to
there-
wait until the end of the what? Do you think it's a possibility that we could be going through the trial and he continues to deny it until he is going to go on the stand on his own and then admit that he did this and this and this because everything is like how do you see this happening? Before trial,
Right now,
at the end
I
of the
don't-
trial?
right now, I see. Okay, so we already seen him. Okay, that what was that one hearing when they started coming up there and the judge kind of laughed? We already seen him slightly angered. I mean, he
The judge?
wasn't very happy. No, BK. He
What-
wasn't very happy
On the hearing before this one.
before this. Yeah.
Yeah,
then
because dude
this-
was arguing for shit that he, like Yolie, right? He was the defense attorney. What's his name? I can't remember his name.
Right.
Logston or whatever. He was
Yeah,
sitting
but-
there arguing shit that he shouldn't have been arguing, because that's what the judge even said. No, you should
Yeah,
have been
but-
arguing it in a different way. I think that's why BK was frustrated, because he
I
sat there
don't
and he
know.
knew it.
Well, here's
He
the
knew
thing.
it.
I have two thoughts about that.
Yeah.
Like, if BK is really smart, he's going to look at that statute and he's going to take it literally. And maybe he's the one saying, you need to argue this.
Yes.
You need
Because
to
he
argue.
thinks he's smart.
It's possible. He may be saying, because look, if I were a law student not knowing much, I would say, the statute says this. So it should be beyond a reasonable doubt. Okay. But the problem is any seasoned attorney or any attorney who graduates from law school, I passes the bar, is going to know. So it's kind of like you have a statute, and just as an example, you have a statute that says, okay, for instance, example, every time you come in my courtroom, you have to kiss my ass. Okay. So some people may take it literally, where every time people come into the courtroom, they actually have to go and kiss the judge's ass. Okay. But the Supreme Court, okay, so that's the statute, literally. But the Supreme Court has said that's not what it means. It means every time you go into the courtroom, you have to respect the judge. You have to you have to show some respect, right? That's just an extreme example of how statutes are interpreted. And you know what? The statutes
All
themselves,
interpretation.
it is interpretation by the appellate court. So the statute themselves don't mean anything. You have to look at the annotations. And that's what I always tell young attorneys. Look, you're looking at the statute. Okay, what you need to do is look at the annotations and how it's been interpreted with facts pertaining to your case. Because the statute is a statute. It is true that if you take literally what the statute says, it might mean something else. But if 100 years have passed where the statute's being interpreted in a certain way, it's the law, regardless of the literal meaning of the statute. I've argued, oh my God,
It's
I've argued
basically like reading the Bible and interpreting a different
Right.
way. To
A
make it
different
fit
religion.
your-
Yeah.
Yeah.
Some
And
can wear
so-
pants, some can't, kind of shit.
Yeah.
you know?
So while
Right.
the court in the Koberger case was saying, back in the 1880s, yes,
Hell, even the 1600s, Yolie, King George.
okay, yeah. Okay.
King George.
But when the judge said it was interesting that he was arguing that,
Uh-huh.
I interpret that as he knew what was going on.
In this last
Well-
court hearing?
I
Yeah.
interpreted that as,
I
wow.
don't think he knows.
No,
I
I
think he's
interpreted that
confused.
as like, wow, you're really going there. Like,
I got it like, oh, I want to hear more because I want to get into where you're getting this from.
no, I don't know. I
I think he's so
interpreted,
confused.
I would never put an argument like that.
He's smart.
I honestly,
I think he's good.
I wouldn't put an argument like that forth, although I have in the past. It had to do with mental illness and, taking somebody into custody because they're not mentally well and they escape. And the law was that a county entity can't be held liable. But the statute said that the county can be held liable for negligence. So
Hmm.
negligence is typically proved by an expert. So I had an expert, but the Court of Appeals had determined that in the situation, certain facts that I had, it was not believed to be that they were in custody. So the whole issue was regarding, was this person in custody or not? If they were in custody, then yes. If they were not in custody, then not. And it happened to be that the psychiatrist put this person on a hold at a county hospital, and they were transferring him to a non-county hospital to be hospitalized and evaluated for 72 hours. So there was a nurse that took him on a wheelchair, and there were security guards, and this guy took off. They didn't have any restraints on him, nothing. He took off and he jumped off of a parking structure, and he lived, but he was brain damaged. So the statute said one thing, but the case law said another thing. So it's kind of like this. And I get the argument, and I know the judge gets the argument, but it's like, why are you putting this? The only reason why you're putting this forth to me is because you want to change the law. And the only way you can change the law is if you get the ruling, the judge says, I can't do anything. The Court of Appeal has held that this law that says you must kiss my ass when you come in here means you must respect me, not literally kiss my ass. I can't do anything. So they take it up to the Court of Appeal, and then they take it up to the Supreme Court, and they try to change it. They try to change it, but it's a legislature thing. The law, the code is a legislature thing. The legislature has to change it. So it's really, why are you wasting my time here? And I did think that maybe Brian Koberger wanted the attorney to argue that, but at the same time, I don't know, because if you honestly believe that the legislature should change the law, then this is what you do. But I have no idea. I only know that the issue was when the grand jury asked for more information, 6 grand jurors, what was told to them. And we don't know that because it's in the grand jury transcripts, because before they decide, they're given the law on probable cause. So you have to assume the grand jury knew or were
I'm thinking they were told, look, we have the DNA, we have the cell phone. You don't need the real photo.
And
I think they were told, this is all you need. This is probable cause. This is what we use to apprehend this gentleman. This should be good enough for you, grand jury. You shouldn't need anything more that's in these documents. And that's when they said, oh, you're right.
Not an argument.
You're right.
No,
I'm not. No,
the defense is not
the
there.
Generalization. It's
no.
I didn't say the defense was there.
No. I get that is probably what was said. It's probably what was said. I agree. And so, but I don't know what the transcript said, but I agree with you, CJ, that it was something along those lines. And if that deviates from the definition of probable cause, then that's where they should have attacked it.
Mm-hmm.
You see what I'm saying? Because it is true. The first thing I think is license plate, or the first, like you said, what did you say? The car?
Well, just when you look at all the evidence that's in the PCA, what is the most questionable thing? That's the most minimal that should be able to be provided if you ask, and that's the photo of the vehicle. It's not. It's.
It may not even be the license plate.
I thought it said probable cause was redacted.
What?
Doesn't it say that the probable cause is redacted?
No, I'm saying when it came to the secret grand jury, the grand jury only needs probable cause. And what I'm saying is they just went in there with the PCA information and said, here, that's all you need anyway to indict. When they said, can we at least see the photo of the vehicle? They said, look, we didn't have to release it in this probable cause to be able to apprehend this gentleman, so you shouldn't need the photo of the vehicle either to indict this man. And that's why they were told, you don't need to see the photo. even if you want to, because it's about probable cause, isn't it, grand jury? Yes. Okay, well, let's
Mhm.
indict this gentleman then. Okay. We don't need to see it, and that's what I think is going to happen in court when it comes to this IGG stuff. He's going to be like, "Look, everybody, you don't need it. You don't need it. If they're not going to get the documents, I'm going to tell you, if they do get them, I'm going to shit, because I think if they do, and I hope they do, I hope Bill Thompson gets there December 1st with this documentation, and I hope this trial goes, and I hope we finally find out, even if it's in trial, how in the hell they did this with the DNA, because that's the most important thing. Because listen, if it's true and it's real, and the homework and the documentation shows that, let's go. Let's get this man convicted. But I want to see it. And if we can't see it and it doesn't happen to come out in trial, look at everything else. It's being avoided. It's being avoided. They avoided putting out a reward. They avoided putting out a profile. They avoided putting out a sketch. They avoided.
Yeah. So, and we don't know because we don't have the transcript, but
I'd
it's
love to.
something. Yeah, it's something along those lines, and so I'm not sure why his defense counsel decided to challenge beyond that it was beyond a reasonable doubt because
I
it's
think the Logston thing that was a joke of a hearing. I'm sorry. Especially you spend that much time arguing to the judge, and then at the end the judge is like, "Well, you should have argued it a different way, sir, and you're going to have to take it up to a higher court."
yeah. I
It's like
wish.
Shannon Gray,
Oh,
spazzing out on the court. It was the same thing
I wish
almost.
I could see the grand jury transcript because I
Oh,
would like to know when the grand jury asked for more, like the grand jury had already been instructed on probable cause standard, and then they go look at the evidence, and then they want more. So I would like to know what was said to them in response. That is the key issue. What was said to them in response? And we don't know that, and that still may come out. I mean, he still has to rule on that during the closed hearing, meaning the prosecutorial misconduct, because prosecutorial misconduct may mean that the prosecution said, this is what probable cause means, so you don't need to question this. And that may be wrong. So the motion should have been, they were instructed erroneously on the probable cause instruction rather than.
when do you think we'll find out? When do you think we'll get when do you think the court will determine the decision on the hearing that was sealed? Even though we're not going to know because it's probably going to be sealed, but we're going to know a little bit because of what's going to be happening from future court dates from then. So we'll kind of get a little bit.
We're going to know if BK gets released.
So you think it could be one day that we wake up and all of a sudden BK's released because the paperwork wasn't dropped yet in the Idaho?
Well,
In the
see,
Idaho,
the paperwork that she is requesting has to do with discovery, right? She's asking for discoverable information regarding all of the paperwork that regards to the IGG, right? That's discovery, right? So the motion is actually separate. It's a motion on the grounds of prosecutorial misconduct and grand jury bias. So he has to make a separate finding aside from the IGG. It may include the
yeah, I
IGG.
know. When do you think we'll get that answer? That's what I'm asking you. When do you
Look how
think
long-
we'll get that?
Look how long it took for the judge to make a ruling on the IGG. She filed this motion way back when.
So do you think he's going to wait until he finds out after the 1st of December what's going on with,
It makes sense.
and then he's going to wait to then determine the grand jury indictment stuff that was sealed off until after they figure out if the documentation's coming or not?
I mean, it could be interrelated like that where that's happening, but it took him a long time to issue a ruling on the IGG.
It was.
It took him a long time to issue a ruling on the cameras in the courthouse. So it's taken him a long time to come to these rulings. And when he said, hopefully this won't be a 32-page, ruling, he's taking his time. He's going through it, and with the, fine-tooth comb. I don't know what the procedures are in terms of the time limits, but it seems like he's taken a long time to do these things. And I keep reminding people that no, the motion was denied as to the instructions to the grand jury. The motion that was brought by the defense saying that they were instructed on probable cause rather than beyond a reasonable doubt, that was denied. But there was the other motion in the closed hearing that hasn't been decided. And that motion is about prosecutorial misconduct, grand jury bias, and who knows what else. And so when the defense attorney was arguing the second motion that was about the grand jury instructions, he slipped out. It slipped out. Well, 6 grand jurors wanted more information. And the judge said, we don't talk about the grand jurors here. This is not that motion. But he slipped it out because he wanted.
Was it a slip?
Right, like a purposeful
Oh
slip.
no, it's purposeful.
Yeah.
Yeah.
So he wanted to put that idea in people's minds.
Maybe that's why Ann Taylor wasn't up there speaking then, because she didn't want to be the one to do it.
Oh yeah, God.
You do it so it doesn't look bad. I mean, I get it. You know what I mean? No, you are the leader. You know what I'm saying?
Yeah. So we still have to hear what he has to say about the motion that was that was closed. So we have to keep in mind that there are discovery motions, which means you're asking for things. You're asking for things that may not come into trial, but that you are entitled to. And then there's motions to dismiss, right? The one about the instructions to the grand jury was denied. He denied that on the spot. He didn't need to take time. So I wouldn't have expected him to take time, because it's like I said, you have a statute that says you must kiss my ass when you come in here, and then you have hundreds of years of appellate courts saying it means you must respect the judge. And so, you can't say, oh, it means he didn't kiss your ass. So therefore they weren't instructed properly, because the instructions should have been, you must kiss his ass. It's silly.
Yolie boom, right there. That's a Yolie boom.
That's stupid. Why would
Yolie
you
boom.
argue that? You would never argue that.
That's gonna be a new thing on the show, Yolie. When you're up here on
Well,
panel,
no,
you're gonna have Yolie booms. Yolie boom.
I mean, I know that. Okay, so that was a stupid argument, and most people know it was a stupid argument.
Oh, the fire! I love it.
Now, if I knew what the grand jury was told in the transcript, if I knew what it was, and I knew that it was wrong, then I would bring a motion that they were improperly instructed on the probable cause standard, because after they were instructed on the probable cause standard, they looked at the evidence, they had a question, and then they were re-instructed on the probable cause standard, which is a no-no. Look, you instruct the grand jury on the probable cause standard, they look at the evidence. If they want more, you don't have it, sorry. But if you have to re-instruct them and explain it, then I want to see what's in the transcript. And 100%. And I don't have that ability to look at the transcript. Nobody does except defense counsel. So I don't know what happened.
That's why I make it as simple as telling people, look, if I'm pulled over for speeding and I know I wasn't, show me the radar. Show me the radar. Because I was looking at my speedometer the whole time. So if I'm going to be accused of going way above that, I'd like to see where's the radar. It's that simple.
In that fact right there, if your transmission is acting up, it could show that you were speeding and you weren't.
Oh my gosh, Un-rav-el. That's why we love you. That's why. Un-rav-el boom. Un-rav-el boom.
Yeah, yeah.
Love it.
And that's my humble opinion on the whole thing, but I don't know about cars, so I wouldn't even know what to say.
Well, there you go. Unravel, boom. If your transmission's fucking up, you might not know it. And I would hope your transmission's not fucking up and then you're getting pulled over too. That would be a shitty
Well,
night. I'm just
that would
saying.
throw the radar off. I would.
that would be a shitty night.
She's the Marissa Tomei and my cousin Vinny.
Oh, I
Not
love
in
it.
court,
I
though.
love it. I love it. I love it. It's good shit. All right. So I'm going to rewind it back to what Bill Thompson was saying. He's basically, going in saying, look, this is what we've been saying this whole time. It's a really good back and forth. And Ann Taylor is just top notch in this. I just have to say. And those glasses, keep wearing them, man.
At the last hearing, the state wanted to sort of find out how quickly they could get some of this IGG information back to the court so I could review it. So start with you, Mr. Thompson.
Thank you, Your Honor. Well, we met via Zoom or Teams or whatever you call it with the folks from the FBI on Monday, and we had shared with them already a copy of Your Honor's order, and we have now sent a 2E letter, which is the formal request process we have to go through. They indicated that they would try to see if it could be expedited. The 2E letter has to go all the way back to Department of Justice and route through its bureaucracy. We asked for, give us an estimation, and they said, well, it could take as long as a month. And so that's where we are right now. We're already in the process of making sure we've gathered everything from the private contract DNA company. So we'll have that ready to submit along with what we received from the FBI once we get it.
Okay, and has it been specified in terms of what kinds of information they have and may be willing to provide?
We gave them a copy of Your Honor's order and said, and the 2E letter says, please provide all information that the court has directed in the attached order.
Okay, thank you, Mr. Thompson. Let me go now to Ms. Taylor.
Thank you, Judge. Your Honor, if I'm understanding Mr. Thompson correctly, the court should receive information from Off-From Labs for the work that they did, probably ahead of the work that the FBI did. If reading between the lines, that's the private lab, and I think the state has more ready access to all of the Off-From Lab work and filings. So I guess where I'm at is I would still ask the court to set deadlines for each, and if they're to come in separate pairs or separate sets of information, that's okay. But I think the court could set deadlines for the Off-From materials as well as the FBI materials, understanding that Mr. Thompson estimates at least 30 days. But you have some additional questions and requests for that process when the time's right.
Okay, thank you, Ms. Taylor. Yeah, I was going to go back to you, Mr. Thompson. Go ahead.
I think that it could be misleading to the court to only have partial information to work with, and it'd be our preference that we make a complete submission all at once. Because Your Honor can't assess all of what's out there without seeing all of what's out there and seeing the interrelationship between it.
All right. Because the private lab and the FBI were sort of working together. Is that what?
No, I think as Mr. Nye described in his briefing on this, the work began with the private lab, and then there was a transfer to the private lab, from the private lab to the FBI, and there were also reports the private lab prepared, preliminary reports that were sent to the Idaho State Police Laboratory, and they all address the same things and overlap. And so it would be, from our perspective, because we've been trying to sort through this ourselves. We're inviting confusion for the court if you don't have everything in front of you. If you're just trying to look at this piecemeal. I mean, we're happy to give it to you however your honor wants. It's just a heads up that your review before having everything is not going to be particularly productive.
All right. You want to respond to that, Ms. Taylor?
I do. Thank you. Your Honor, I would not expect a court to make decisions about Othram without having the full scope. It's just been a long road for us to get information. The court is aware after our third motion to compel and the state's response that we were going to get SNP profiles. And I know that the state waited until they had the FBI profiles available to get us the SNP from Othram. Your Honor, we will have further discussions later about that, but I think that there's missing information from the Othram profile that we have. I'm hoping the court gets it, and I certainly understand that the court needs to see everything to make a decision. My hope is that everything includes communication so that you can follow the path of what happened while you make your decision as well. I wouldn't expect you to release it or decide what portions would be released or what orders might apply until you see it all.
Can I ask Yolie a question?
Deadlines in place
Yeah.
so that you can.
Okay,
Yeah,
so
go ahead.
this is, I'm wondering about this. So, so the prosecutor doesn't hand over directly to defense, right? He has to go through the judge, and then the judge picks and chooses what he wants to give to the defense. Is that how it works?
No, the prosecutor has to hand over everything related to the investigation of the defendant. That's in the beginning. They have to hand over everything. And it's way more liberal than
whatever they have, right?
Whatever they have or whatever is reasonably in their possession. So when the FBI or the Idaho State Police step into the shoes of law enforcement, it's like the judge said, they were part of the investigation. They have to follow those DOJ guidelines, those DOJ, the protocols. Okay, because you can't have different agencies doing different things. I mean, you have them come in to help you, and granted, the Moscow Police Department can say you do this, this, and that, but they have to comply. Because they're in an investigation against a defendant. So a defendant who's being accused of a crime needs to have all that information. So the prosecution could say, well, I don't have it because the FBI didn't give it to me, or it's in the FBI's possession. Okay, that's two things. If it's in the FBI's possession, then you need to get it from the FBI. Okay. If it doesn't exist, then you need to get something from the FBI that says it doesn't exist. So by him saying, we've given everything. We don't know. I mean, the FBI, I don't know what that, no, the obligation is on the prosecution to get that information, and it should already exist. If the FBI was, and I swear, I got to get those DOJ protocols, and Taylor attached it. If the FBI and the Idaho State Police were involved, they have to follow it. And the whole reason why they have to follow those protocols is so that you don't have this problem. It's, you're working together and you're working as one agency. We're not working as three agencies. Even if there's a parallel investigation, when it comes to this defendant, whoever was involved in investigating this defendant steps into the shoes of local law enforcement. Okay. Now we also
it's really up to the Attorney General or the defense,
Sorry?
Whoever the FBI have to go through the big okay, and then he passes it down.
I don't know about that. All I know is what's in the Department of Justice protocols. So, you can't have outside law enforcement come in and not do their job and not document things, and then have the defendant say, okay, we want this. And these other law enforcement agencies are going to say, we don't have it. And the prosecution, local law enforcement, would say, we don't have it because they don't have it. No, it's not intended to work that way. When you have a small public entity that needs help, and I do want to get those.
This is interesting.
I do want to, and she's mentioned it. The Department of Justice. You can't have somebody's civil rights violated because other law enforcement agencies were helping the local, and those other law enforcement agencies didn't follow protocol.
So they have to supply
But
whatever
they are though. It's the
They may.
who is, because he has to go through it and okay it.
Who?
The head of FBI.
Well, that should be covered under the Department of Justice protocols. So
There, yeah.
it's all, and she attached it to her motion. Okay, a motion way back in the day. And this whole deal about jurisdictional stuff, like people are saying, oh no, that's federal. This court has no jurisdiction over the federal. They can't make him produce. They
Right.
can't make federal people. No, that's not true.
Exactly.
It is not true.
Oh,
Okay.
Not
I don't
true.
know.
And the court.
Loving this conversation.
Well, the
Yeah, keep
court
going.
just made an order saying that, and Scott Reich talked about it as well, that
Shout out Scott Reich.
yes, he's a criminal.
I love
defense-
his channel. I love his channel. Always have.
He's a criminal defense attorney.
Yeah,
So,
in
Right.
Denver.
so it's, if you request the assistance of outside law enforcement like the Idaho State Police or the FBI, there are certain protocols they have to follow because they are stepping into the shoes of local law enforcement. Okay, the issue here becomes when they arrested him in Pennsylvania. Okay, so I don't know about how that works, but I do know that the investigation that was done in Idaho by the Idaho State Police and the FBI, that's presumed. There's a presumption that the prosecution has it in their possession. And that's what the court said. You can't hide behind that. You can't prosecute someone and use outside law enforcement and say, oh, we don't have it because outside we can't get it. No. A defendant has a right to cross-examine his accusers. Defendant has a right to cross-examine the people who did the investigation. That's within the control of the state. And the court said that, and Scott Reich said it as well. He said,
Yeah, that's where he should have stayed with the first plan he had. But now, because he changed it, this is why.
The first plan?
Yeah, when he wanted
Like when he
the
was
speedy
going to do
trial.
in the silent, the speedy trial.
We
And then
should
they
have
didn't
stayed with the
respond.
speedy trial.
No, I don't. You can't. He's entitled to a speedy trial. He doesn't have to have it. If he needs more information to ensure that he is not guilty,
What's
he
up,
can
Cindy?
waive it.
I was surprised. I was surprised that they did all that stuff leading up to it and then they didn't respond. I was also surprised, remember, Yolie, when I was mentioning that
Oh
I
yeah,
thought
we
they
had
should have
that.
kept putting pressure on him and
No,
you were kind of coming from the spot where you were like, no, I don't think they should.
nope. I don't. You know what? You're talking about life and death. If it was money, yeah, you put the pressure on him. But if it's life and death, and you have a prosecute, you have a duty to make sure you have everything to prove. Well, you don't even have to prove he's not guilty, but you have a duty to make sure you have everything in your power to make sure your client gets off 100%. If you don't have
Especially
everything
if
that
you don't even have the profile, the DNA, you don't even have the chain of custody.
You don't. So you want
ridiculous.
to prove prove that. You want to show that. So, and if you show that, well, he may not even be in custody. He may be let go, and there won't be a trial.
Right, he does. He has a right to face his accusers. And
Exactly.
like when I put it as simple as, if you're telling me I'm speeding, I know I wasn't speeding. Where's
It's not
the
gonna
radar?
happen.
Where's the
I
radar?
told you that a long time ago. The FBI stepped into the shoes of local law enforcement. Now, what they did when they went to his home and the SWAT team went to his home.
Well, wait, is it really stepping on toes, or is it them asking them for their assistance for the things that they provided?
Well,
Right? Because I think they reached out, because I don't think,
they
I've
did.
always said they just had experience on noise complaints and busting underage drinkers. When it came to looking through surveillance, I'm sure they said, hey, can you guys do this for us? When it came to the DNA, and the ISP lab couldn't come up with a hit, and they sent it to the cold case laboratory, and then they said, hey, can you guys do this for us too? I think
Yeah.
I don't know if they necessarily stepped on toes, but I think MPD reached out to them because they didn't have that
It is
experience.
true.
Right.
So when
But
they
I do, yeah, they were definitely involved in it, though, like you
yeah, when
say.
they reach
Sure.
out to them, they're asking them for help. So when they help, they step into the shoes of local law enforcement. Like if I'm asked to help a defense counsel, then I step in the shoes of defense counsel along with defense counsel who asked me to help. I mean, you have multi-jurisdictional people who are helping, so there has to be some method by which a defendant can make sure that he can cross-examine his accusers. So if you have multiple agencies, you cannot say, oh well, we're a county, and this Idaho State has evidence, and we don't have it. I mean, I don't know if they have it. And the FBI was involved in witness interviews, and they're the ones who told us about this, but we don't have it. No, it's not how it works. I want to get the Department of Justice protocols because Ann Taylor attached it to her motions, and at one point I knew it. At one point I read it.
She even said it right here. She's like, I was asking, I thought I was going to get this certain part of documentation, and I didn't even get that.
Yeah.
Is what she's saying right here. Like,
Well,
I didn't get it.
She did mention the Department of Justice. It's the Department of Justice. They're local law enforcement, when they need help, they all have to work together. And you can't piecemeal and say, well, the FBI has to go through this and the FBI. No. If I don't know criminal law, and I'm sure Ann Taylor is really good, and I probably would be like a green. But you know what? I don't care. If I were the judge, like,
I would love to go to school to do this for real.
but I guess I don't know all the reasons, but in my
I would
mind,
love to be a lawyer.
I would say, when Moscow, Idaho asked for help in catching somebody, we want to catch the right person. So we want the help, like Idaho State Police and the FBI, to keep records, to keep track, so that we can, right?
Funding.
Well, regardless of funding.
No, it's funding.
Funding, you ask for outside help, right?
Funding makes sure you have your job. Funding makes sure that you can continue to afford everything that you're continuing to afford. Funding allows you to live the life that you're continuing to live.
They had 30 to 50 FBI agents there. This is what I heard. I don't know if it's true, but that's
I heard more than that, but the numbers, who really knows? You know what I'm saying? I heard more, though, slightly more, but there's, like you said, even down to 30.
So funding, yeah, they had
for the MPD.
They had enough to fund 30 some FBI agents to assist.
Think about it. They had enough to fund the Banfield cars where they were driving around Ford Fusions that you know what I'm saying? That were their undercover alcohol enforcement
And
vehicles.
and
Like that's
so
money.
so my point, just to wrap it up,
Yeah.
the court can say the prosecution has to get this information. If it doesn't exist, then the prosecution has to say it doesn't exist. They've already said it doesn't exist, but they need to check. They haven't said it like
Yeah, saving
unequivocally. They haven't said it unequivocally. They said, well, we don't know. And then he keeps saying, well, I don't want to give the court, or anybody any misleading, they may not have it. We've already requested it. We showed the order. Yeah, they showed the order to them on Monday. And then Tuesday and Wednesday, the FBI was out there at the house. Come on. I'm not stupid.
Well, before we get back to this court hearing, do you think, after all this discussion, do you think that documentation is going to be provided when it comes to this trial then? I don't think so. To me, it sounds like both of you think it is, right?
Yeah.
Well, I think that it might. Yeah.
Okay.
It will.
And I'm on the side
In my
where
opinion.
I don't think it's going to be. Okay. That's interesting. I'm glad.
I think it's going to be a huge jump. Boom.
Yeah,
Okay.
I actually kind of think that too. I think they're just
Okay.
But I think if it is a huge document dump,
I hope so.
the documents have to be scrutinized as to when they were prepared.
I hope so. Scarlett says December 15th.
Yeah, I don't know. But I think that something's going to be dropped. It's like you said, at this hearing, they're going to produce nothing. They're going to produce a tip. Remember you said that?
Yeah, that's all they're gonna. That's all they're gonna. Yeah, I said it before the court hearing even started. I was like, "Listen, guys, they're just gonna walk in there and they're gonna say, here's the tip. We don't have the homework. We can't get the homework because of everything else that we've been telling you this whole time, court." That's what I'm looking at. Like, come on.
But the court has said you must.
Thank you, Kelly.
If it doesn't exist, then we
I
need
love you guys.
some kind of documentation that doesn't exist. So the document drop that you're going to get, I agree with Un-rav-el. There's going to be a document drop probably, but it's questionable. When was it prepared? What did they do?
How much is in it?
It's suspect.
That's another thing too. How much is even going to be in it? Just because it's, what's the document drop? Does that consist of 2 documents? I mean, yeah, is that a document drop? I guess it is. No, because one is a document drop, I suppose. But I mean, yeah, we could easily get documents and I'm sure we'll get something, but how much is even a question too. Yeah, it could get a piece. Well, here's what we do have, which could be very minimal. I want everything. I really hope that they're going to do what you guys feel. They're going to come in there and there's just going to be all sorts of these documents and we can get on with this trial and get on to the justice and the truth.
Yes.
What's up, Jesse? Jesse had a question for you earlier, Yolie. If you want to remind everybody, and then we'll get back to this court hearing.
I told them.
If you want to let everybody know what happened, and then we'll go ahead and get back to it.
I told them my trial got continued.
Oh, there we go.
26. This is ridiculous.
Yeah.
I spent 2 days on Zoom on standby just to.
Yeah. Oh, we were on standby today, Yolie. I had it on. I had your court hearing link on standby for the show, but I saw it said something like you needed special permission, so I was like telling everybody we might not be able to watch it.
You can, the court has live streaming, so
yeah,
for trials they will live stream.
You just can't duplicate it.
Let's not talk about that. I'm frustrated.
It's delayed, so we're we're going
over today. Let's just
so we're gonna do this. Was
that the question that Jesse had, or did he have some other question?
He had another question earlier this morning. Jesse, do you remember the question you had earlier this morning? Who is Nathan? I don't know who Nathan is.
Oh, I've heard that name. Where did I hear that?
I don't fucking. I have a cousin named Nathan. I mean, I don't. I have a buddy named Nathan. I got a couple friends named Nate. What do you? Ooh,
Nathan.
what? What?
Nathan, I've heard that.
Yo, Nathan. My question was, what do you think is at stake for Judge if it becomes clear that this case could be overturned on appeal?
Mm.
That's a good question, Jesse.
Well, yes, the judges are always
They're self-conscious as well,
yeah.
right? I mean, that's a
And
self-conscious question, I'm sure.
I really wouldn't want to be in his position because this is a case of first impression in Idaho. So he's going to have to be careful. And when I say it's a case of first impression, it means this hasn't been dealt with on appeal. And so there's another case that they cited, which was not an appellate case, but it was a similar case where they had hair and they were saying the IGG shouldn't be turned over. And the judge ultimately said, yes, it should be turned over. But they had hair, they had more DNA than they did in Koberger's case. So, yeah, I'm this is a case that might set a precedent for the Idaho Supreme Court.
For everything,
yeah,
good
so
and bad, it's going to
'cause
change a lot.
California has some cases on it, and they try to use it as persuasive authority, although it's not. I mean, it is, but it is really. I wouldn't want to be in this judge's position because that's why he said he may have to have somebody to come in and explain to him this whole DNA shit.
Yeah.
Because I get it. At certain points, I get it, and I have my head wrapped around it, but then it escapes me. And
Well,
like,
it's
SMP, STP, 2 profiles.
right. I mean, and that's what I was saying to people, even in other shows when I'm making comments. It's like, look, the potential juror members haven't even been sent a letter yet, and they could literally be sitting in our shows watching this stuff. That's why I'm so, when it comes to certain things that I'm not exploring, it's for a reason, because I understand that there's potential juror members out there in the future that could be watching these shows right now. And so when it comes to this DNA stuff, that's what I'm afraid of, is that the jury, just like the judge, it's pretty clear already, doesn't understand this DNA stuff. And it's so important. And so when we are talking about this DNA stuff, we do have to also, like why I made that read through 10-minute video earlier this afternoon about reading that article, is because it is so important to know the handling, the chain of custody, the workers' performance issues. If there's any, if there's any, anytime they got in trouble, was there any mishandling? Was there any contamination issues? Where, all of these things, because that is so important before you even get to the profile of the person. And when I'm sitting here this whole time, because I've never done a 23andMe or anything, I'm sitting here this whole time thinking that you have to provide some kind of documentation to show that you are who you say you are. And then a few days ago, I find out from you guys that no, you could put Joe fucking Dirt on there, and Joe Dirt could have real DNA out there. Like, it's crazy. So it's so important to know how you got the profile, how you got to the profile, and how it was handled. And it's so important to be talking about these things, because I have a feeling this is where those potential juror members in the future, if they are watching these shows, which they probably will, because they don't even know that they're a potential juror member yet, they're going to have some kind of understanding. And I hope they do, because yes, it's going to set precedents for the future, and it's going to be good and bad. And I hope that all of this stuff is based on the understanding of all of this. And unfortunately, I don't think it will be, because you have even the same people that are proficient in this science don't even say that it's science. They tell you that it's art, because it's not a science yet. That's so dangerous.
Yeah. That's why it's a tool. It's like polygraph. you know, you give a lie detector test. There are people who can pass the lie detector test. I mean, there are people who
Right.
they can pass it. So it is a tool of
Right.
investigation. And so, yes, it may be discoverable, right? But it may not be admissible in court. I don't know the answer. And I know that the judge is overwhelmed. I would be too, because like we had this discussion a long time ago and I thought I understood it. And I thought, okay, you get these strips, the STP and whatever. And now it's like, what the hell? At one point, I think I did really understand it, but now, because time has passed, I'm saying, like, I need help. Like, I would be like the judge. I actually would need like an expert. And, you know, he said, if I need to bring somebody in here to help me understand it, I will, because he wants an independent person. Like, you know, Koberger's attorneys brought in experts for that hearing. So that whole hearing we had where they had those Brick Barlow, that man that testified, and Gabriela Vargas, he just ruled on that motion recently. So that's how long it took for him to rule on this motion. So, and people forget that there are motions pending. And I don't want people to forget that there is still the closed hearing motion regarding prosecutorial misconduct and grand jury bias that is still pending. I don't know when he's going to rule on that, but that's still pending. So when you have things, and there's discovery requests that are still pending. I mean, she's submitting, I guess it's called supplemental discovery requests. She's praying to the court, like, I need this. They're not giving it to me. You need to decide. In civil, it's a motion to compel, and they get sanctioned if the judge says, yeah, they need to have it, and you don't have it, then you're sanctioned for the amount of time it took her to do this motion. But I don't know in criminal law. But so, yes. So back to Jesse Schul's question, I would be stressed. And yes, I would want an independent expert to advise me on how to interpret this, how to handle this, because at one point I did understand it. I think we all did. Remember, we went through that whole thing,
Yeah.
talked about it, and I did understand it. I mean, I thought, okay, this is the learning experience. It's a tool. There's STP and SNP, and
Should
there's
we do another DNA show where we explore the differences of those? And
or
would you both like to be on?
well, you know, I don't even know if what we were saying back then was even right. You know what I mean?
No, we're going off of CC Moore and Vargas, you know, experts in the field.
But
The ones that, you know, understand all of the sciences. We're not going to understand it because we're not in the lab. But we definitely do need to, I mean, if we're going to be responsible, we do need to explore the whole difference between the profiles.
because
And
there's two now, apparently, SNP profiles.
so we can do it. If you guys aren't busy tomorrow night, we could always do a show about the differences. No, for real.
Yeah, well, my trial got continued. So
Yeah. If you
Sounds
guys
good to me.
aren't busy, if you guys would like to, we can just make that a dedicated show where we explore the differences of the different DNA.
well, we
Let's
probably
get educated. Let's educate the community. Like I
I
said,
thought
we never know. Potential might be watching this.
I thought I was educated, but I don't know anymore. It's like so many things have gone, and it's like I thought I grasped it at one point, and I think we all did. But it's kind of like
You're exactly right. No, you're exactly right. That's why I just was like, you know what? Maybe we do need to have a show. If you guys aren't busy tomorrow night, maybe we do need to have a show where we explore these different DNA profiles and the different, you know, how it's, you know, conducted, how they reach their conclusions, you know, the science behind it. We may not be able to understand it, but that's the beauty of doing it as a community, is if we do it all together, we get a hell of a lot closer than each one of us might have been before we even started doing it together. So we can, if you guys aren't busy, I'll definitely make it a show tomorrow night if you guys want. I would love to.
because it is educational, and you know, it goes to
Right.
show that when I go to trial, like I understand everything, like I do, and for this trial that I was going to do, like all the vascularity and the, you know, the maxillary and all the you know, the wisdom tooth and the numbers of the tooth and everything. But then, you know, like I do the trial and then it's gone. It's like I don't need it anymore. So it's kind of like the DNA. I think I once understood it. But now maybe a refresher is in, you know?
Well, for sure. That's why, I mean, it sucks that it got delayed, but at the same time, I appreciate you being up here, and I'm glad because now we can use more energy of that transformer effect to try and push for the truth and justice even quicker, because just talking about it is making a difference. So
Yeah, and then Unravel's videos, I don't have that knack with the videos. I mean, I can barely, operate.
well, we're gonna, what days are you off? We'll get back to this court hearing. What days are you off, Unravel, coming up the next week? Because I'm going to do some
I got the
special
weekends off.
shows the weekends. So Friday nights through Saturday and Sunday.
Yeah.
Okay, because I got some
I mean-
special shows coming up, and I would love to have both of you guys with me, and I'll reach out to you and kind of discuss that with you guys. Nathan, yeah, what's up, Nathan? It's going to be very interesting. I don't know. I hope that these documents, like you guys feel, I hope they do, because really, if there's a bunch of other cases that we could be talking about too, but it's like there's so much injustice I feel that's happening. In my opinion, that's why I keep discussing this case, and have been since the beginning, because honestly, from the beginning, none of it has made sense. And so, um, I look at it as if it was me in that same position, I'd be appreciative of somebody doing this. I think, I don't know. I don't, I hope I'm wrong. I hope I'm wrong about this December 15th being the day that these documents could drop. I hope I'm wrong about it not being until February 1st, until the court says we're not going to get these. We have to move on. I hope I'm wrong about that. I hope I'm wrong about feeling like the house is going to be demoed during the holiday break. Especially with the interview that Brian Enton had with the family, the Concalves family last night. And that was a topic of conversation about the house being demoed. And when you hear them talk, you just have to, it's like, no, this cannot happen. But we'll get to that after this court hearing, though, because there is some Brian Enton snippets that have been dropped during the show. So basically, Bill Thompson was basically saying, look, we've provided all the documentation. Ann Taylor has gotten both profiles. We've given up all, everything that's been asked for. There's other agencies that are involved. And, it's a waiting game, is what he's basically saying, and that it typically could take up to 2 months or up to a month. But, basically it's all out of his hands, is what he was saying. Ann Taylor's response is, we were given documentation. We thought we were going to get more, considering what we were asking for. They didn't even feel like they had the sufficient documentation to go with the documentation that they went with.
Yeah.
So it's more, it's a good back and forth. So we'll get back to this, and then we'll get to some of them Enton snippets. Un-rav-el, if it's okay, if it's not too late, we'll see how late it's going to be. Might have to do your videos tomorrow, and we could always do those in the intro before we go into the different DNA stuff.
Yeah, I mean, I can always go to the channel and look at them, but
no, I want to highlight them too on the show, because I know a lot of questions from the community are going to be asked as well. So,
No.
Oh, sorry. Go ahead.
No, that's okay. I was going to say the last video it looked better, I thought, but that's it.
Is that the blue one? Does it have blue lights or something?
It might. It's the last one.
Okay. I think I didn't see it, but I saw it. I saw that you had it, and I was going to watch it, and I got distracted. But yeah, we need to watch those.
Well, and Also, when it comes, I'd like to see let us know if you have a video where you did the different hand gestures in the court hearing. Um, and if you don't have it, maybe that'd be something cool to showcase tomorrow night too, because I think that would
Yeah,
be a great video to play, you know?
I'll work on that. And then I want
Thank you,
to
Taylor.
highlight something on his face expression when on a certain point too.
Yeah, do it. I'd love to showcase it. I'll probably set the live for like 7 o'clock Central, 8 Eastern tomorrow night, maybe 6 Central, 7 Eastern, somewhere around that time period. So,
Okay.
yeah, that'd be sweet to showcase that too. All right, so we're going to go back to this court hearing, and there basically is just the introduction of what's going to be taking place.
The Idaho State Police Laboratory, and they all address the same things and overlap. And so it would be, from our perspective, because we've been trying to sort through this ourselves, we're inviting confusion for the court if you don't have everything in front of you, if you're just trying to look at this piecemeal. I mean, we're happy to give it to you however your honor wants. It's just a heads up that your review before having everything is not going to be particularly productive.
All right. You want to respond to that, Ms. Taylor?
I do. Thank you. Your Honor, I would not expect a court to make decisions about Othram without having the full scope. It's just been a long road for us to get information. The court is aware after our third motion to compel and the state's response that we were going to get SNP profiles. And I know that the state waited until they had the FBI profiles available to give us the SNP from Othram. Your Honor, we will have further discussions later about that, but I think that there's missing information from the Othram profile that we have. I'm hoping the court gets it, and I certainly understand that the court needs to see everything to make a decision. My hope is that everything includes communication so that you can follow the path of what happened while you make your decision as well. I wouldn't expect you to release it or decide what portions would be released or what orders might apply until you see it all. I'm hoping that there will be some deadlines in place so that you can begin getting the information.
All right, thank you. My understanding is that that the private lab SNP profile was already provided to you. Is that right, Ms. Taylor?
Your Honor, I received in discovery a SNP profile, SNP profile that I believe came from Othram and one that came from the FBI. The Othram is not the FASTQ file, which is the general format that those come out in. It's a different kind of file, and it's a smaller data file than the FBI data file. And so I think that there's some issues with what we received from Othram. We have that. We have what the FBI file is, although it's missing a good percentage of information, and we'll be talking to the state about some of that later, but they've provided some things. We think it's sufficient.
Okay. Obviously, I'm asking to look at all this because I can't make informed decisions if I don't. Is my understanding was maybe there was one SNP profile, but now I'm hearing that maybe there are two, one from the FBI and one from the private lab.
That's correct, Your Honor. And the difference is the one from the private lab is the initial profile that the private lab analyst created from the DNA, the portion of the DNA sample.
Right.
Then what was transferred to the FBI was after that original SNP had been uploaded to a database, access to the database was transferred. And it's our understanding that once a SNP is put into one of these databases, the database adjusts the SNP to fit what their criteria are for them to do their searches. So there are differences between the two, the entirety of the two SNP. Mr. Nye, you're very knowledgeable on this. Jump in if I'm not stating it clearly. And so in an exercise of caution, we wanted to make sure the defense had both. Had what the original SNP that the private lab created, and also the SNP was transferred via the transfer in the database to the FBI. We wanted to make sure that we weren't overlooking anything. The FBI saw, or the defense saw both of them. And we are told, we understand that, like I just said, the databases adopt the SNPs to their search components, and so they're going to look slightly different.
Okay, thank you. You want to add anything to that?
So, what did you both take away from that? Did you take away that it was the same profile, just one was an enhanced version because it was transferred from one database to another database that had more availabilities and options? Or do you think it was two separate people?
It's the same.
That's what I thought too. That's why when I first heard it, I was like, "Oh, did he say two?" And I made a note of it, but then I woke up the next morning. I'm like, I need to review that again because maybe I'm hearing it wrong. And that's when we reviewed it. Yeah, and it was like, no, it's transferred. It's an enhanced version. It's not two separate ones. I don't know. Maybe I'm wrong though. I could be wrong too. But that's just how I took it. What'd you take, Yolie? Or do you want me to play that part again where he discusses the two profiles? Jethro, you're being funny as hell tonight. Thank you. Appreciate you. Your comedy is funny. Oh shit, Nina. That's ouch. What do you think though, Yolie? What do you think about what he said? Do you think it's two separate people or just one's an enhanced version because it's in a different database? What's up, Cherry Cherry? You're on mute, Yolie.
Sorry, I was on mute. I think one is enhanced but they're the same.
Right.
But I'm not 100% sure, but that's what it sounds like.
I can play it again one more time. I mean, because I had to listen to it a couple times. Hell, I had to review it again the next morning to really, like listen to it. And then we discussed it that morning on the morning show. It was like, yeah, it's in shout out Katrina mentioned the enhanced, and Angel as well, the enhanced version of that profile. And it's like, yeah, that's the word I'm looking for, like enhanced. An enhanced version, same profile, just an enhanced person.
I'm sorry. If I could listen to it one more time, I think it is the enhanced, but
yeah, let's do it.
All right.
Hold on.
Now I'm hearing that maybe there are two, one from the FBI and one from the private lab.
That's correct, Your Honor. And the difference is the one from the private lab is the initial profile that the private lab analyst created from the DNA, the portion of the DNA sample.
Right.
Then what was transferred to the FBI was after that original SNP had been uploaded to a database, access to the database was transferred. And it's our understanding that once a SNP is put into one of these databases, the database adjusts the SNP to fit what their criteria are for them to do their searches. So there are differences between the entirety of the two SNPs. Mr. Nye, you're very knowledgeable on this. Jump in if I'm not stating it clearly. And so in an exercise of caution, we wanted to make sure the defense had both. Had what the original SNP that the private lab created, and also the SNP that was transferred via the transfer in the database to the FBI. We wanted to make sure that we weren't overlooking anything, and the FBI saw, or the defense saw both of them. And we are told, we understand that, like I just said, the databases adopt the SNPs to their search components, and so they're going to look slightly different.
They're going to look slightly different, but they're adopted into basically an enhanced database than what they were using before, because it went from ISP to Orthram to then the FBI.
So
how do you do all that with that small amount of DNA too?
He's not qualified to say that. he may say that, and I think I understand it, but the people who did it need to be the one who are saying it. He could say anything. I mean, I could get up there and say, yeah, so we put this snippet here and we put this snippet here and we enhanced this snippet and that's why it's different. And so the snippet that we didn't enhance is different and that's why it looks different. Okay, but Mr. Thompson, who are the people who did that? That's what we want to know. We don't.
The FBI.
Yeah,
The
what he
FBI.
says is not evidence. I understand, like, intellectually what he's saying, but did he do it? How does he know this? He must know this from somewhere.
Well, that's
What
what
is
he's
it?
being told,
Well,
you know,
where
from
are
the
those
FBI.
people? Where's the documentation?
The documentation he
He
can't
has the
provide.
guy. He just asked the guy to. The guy's right. He just asked the guy that's there if he's
Mhm.
saying it correctly or not.
I don't know. I understand what he's saying, and I think
Yeah.
it is what you say it is, that it's the same, but it's just that one's enhanced. But I don't know. I mean, that's just him saying it. Now he has to back it up with the stuff.
Well, I mean, and that'll come into trial, you know. We'll listen to it one more time. That's just how I took it. Let's do it one more time and then
But remember that he is saying it. He didn't have
yeah.
any firsthand knowledge of doing it,
Well, it's what he's being told, you know.
which is
Obviously, because he's not in the lab, you know. It's what he's being told, what he was told, what he has documentation of, which he probably provide, which is the same documentation he's saying he provided to the defense, you know. I don't see him saying anything of something he didn't provide. So I'm sure that's the stuff that he provided to the defense. The defense is saying, look, you know, we were given these two, but we weren't given the chain of custody.
Yeah.
You know, like
Honestly,
this is what it,
he can say that, and maybe he has a basis for it or not, but he can say that, and all I have to say is that I understand what you're saying, but the proof is in the pudding. So you show me what you're saying, and that's it.
yeah, that's what I want to have.
That's it.
All right, let's listen to it one more time, and then we'll just ask you guys again real quick after this.
One from the FBI and one from the private lab.
That's correct, Your Honor. And the difference is that the one from the private lab is the initial profile that the private lab analyst created from the DNA, the portion of the DNA sample.
Right.
Then what was transferred to the FBI was after that original SNP had been uploaded to a database, access to the database was transferred. And it's our understanding that once a SNP is put into one of these databases, the database adjusts the SNP to fit what their criteria are for them to do their searches. So there are differences between the two, the entirety of the two SNPs. Mr. Nye, you're very knowledgeable on this. Jump in if I'm not stating it clearly. And so in an exercise of caution,
Yeah, Bodie's
we
being
wanted
told.
to make sure the defense had both. Had what the original SNP that the private lab created, and also the SNP that was transferred via the transferring database to the FBI.
To the FBI. And that's why he's saying, like, correct me if I'm wrong, so and so. It's what he's being told. And so he even reached out and said, look, if I'm stating this incorrectly, please let me know. I'm going to continue to state what is in my report, what I have documented, and what I've already sent to the defense. He's coming in confident as shit. Like, look, I supplied him with everything that they needed. I can't get anything more.
Yeah.
That's why
I
I
have
think
a
it's
lot
going
of
to
questions.
continue to get delayed.
I would be questioning everything. I would drive the judge nuts, but
And that's why Anne's response after this is it's elegant. The whole court hearing, she's elegant with
I know,
the
and that's how you
patient.
have to be. You can't be
You
a
know?
crazy woman. And
No, I think it's going to show good things to the jury. Like,
Yeah.
this,
yeah,
Un-rav-el, you still, to me, it just says an enhanced version. You still
Yep.
What are you? Yeah. Okay.
I'm still with that too.
All right. And then here's Ann Taylor's response. She's going to basically say, like, yeah, we got that, but we didn't get stuff we felt was sufficient to the stuff we got.
We wanted to make sure that we weren't overlooking anything. The FBI saw, or the defense saw both of them. And we are told, we understand that, like I just said, the databases adopt the SNPs to their search components, and so they're going to look slightly different.
Okay, thank you. You want to add anything to that, Mr. Nye?
No, Your Honor, I thought that was very well said.
Okay, thank you. Well, we're all learning a lot about DNA, that's for sure. So, you know, I don't know that I have the capacity to really examine the information piecemeal. I would prefer to just look at it all at the same time because, I mean, maybe there are comparatives here, obviously. So what I'm going to do, and I know that, I mean, this is complicated too, and we've heard this already, just getting complete information from FBI, but apparently it's in process. I'm going to set a deadline for all the information to be provided to the court by December 1st. That should be sufficient time. If something comes up between now and then, I'm sure I'll hear from some of you or all of you. We can have another status conference if necessary. But I would really just want to push this out, or not out, but more quickly as possible so that we can get to a lot of the issues that we really have to address as well. So not that this isn't important. All right, so I think that's really all we need to address today, unless anybody else has some other issues. Mr. Thompson?
No, sir, and I will communicate that deadline to our contacts with the FBI today and let them know if there's going to be some delay. We need to hear about it sooner than later, and we need to have a good explanation for it.
Okay, excellent, thank you. Anything else, Ms. Taylor?
Yes, Your Honor, two things. Your Honor, I am going to request that the court make a privilege log of what the court receives in this packet of information the court's going to review. I will want that to be released to me to make sure the court has a full packet of information to review in making its decision. The other area that I want to talk about is what does in-camera mean? This is really complicated, and I would like to know how the court is going to learn about these things. If the court has to consult with anybody, I want to make sure that there's not going to be an FBI agent in the room with the court or anything like that to try to do the in-camera review to make heads or tails of what this stuff means.
Well, that's a good question. I don't know the answer to that. A lot of what I'm reading and learning from is all the information that both sides have submitted to me or telling me in these hearings. So that's I'm not pulling information from outside of that because that's not on the record. I suppose if I have to bring somebody in to help me understand this, you will know that. Both sides will know that. Another way to look at this is I could have another hearing and you all can help me understand this if that's necessary. I think I have a fundamental understanding about all of this, and that's I think expressed in the order, but I understand this is complicated stuff, and somewhat controversial. So I will do my best. That's the best I can do. All right. Anything else then?
Your Honor, I'm not sure what counsel means by a privilege log. It seems to me to defeat the purpose of the in-camera review if the court tells the defense everything that it received. I mean, that seems contrary. So I don't know what's being contemplated there. We are going to give you everything we get. And if the court has questions, the court can ask those questions however it feels it needs to. If the court wants to bring in outside help to understand in the way of an expert or something, we don't have a problem with that. We want the court to be able to make an independent decision on this, taking into account and considering the concerns that we have expressed through our briefing argument, and understanding the court's interest in ensuring the defense has access to what it legally would be entitled to, and that appropriate protections are put in place on sensitive or personal or private information as the court deems appropriate, so that third parties are not injured by what is occurring.
Okay, thank you, Mr. Thompson. I interpreted that as that the state needs to document everything that they're getting just in case, so that if there is an issue down the line, that is documented. That doesn't necessarily mean that you turn that over to the defense automatically. So I don't know if Ms. Taylor suggested that, you provide all that information to Ms. Taylor before I make a decision in camera. You want to clarify that, Ms. Taylor?
Yes, thank you. Your Honor, what I am hoping that the court will do is just create a list or a log of what the court receives, not the detail of the content, but things like the raw data SNP profile from Othram, the communications between Othram and the FBI, not the content, just that you have those. The statistical analysis that happened within the profiles when making decisions, when the genealogists made decisions about the family tree, that you have the statistical analysis, that you have the bioinformatics for the microarray, that you have access to those things. That's it. That's what I'm thinking that the court would do, is make a list of those kinds of things received. The court should also include that the FBI complied with the requirements in my family tree. Those kinds of things, not copies of them. That's what the court's looking at in camera and making decisions for. And I certainly understand the need for information to be protected. During the course of this case, I've signed orders agreeing things are held in a protected way so they're not used without further order of the court. I certainly understand that need, and that's one of the things that I think the court may get to with this. But the privilege log isn't the content, just a list of the things that you've been able to review to make a decision about.
All right. Well, that may happen. I'm not. It's hard for me to make decisions in the abstract. So, I'm going to see what I receive, what I get, and then I'm sure that the state is going to document all of that, and then I'll make a decision about what is disclosed. I mean, that's the reason for the in-camera review, but I do think that it's appropriate for you to understand exactly what was provided, even if you might not get to see it. But I just don't know what that is. So I'm not gonna, bind myself yet. Okay, until I see what I get and when I get it. And that goes with, if I need to bring somebody in to, an independent DNA scientist, then, you all will get to know that. But I'm assuming that you will.
And I think, like, right there, Bill Thompson's licking his chops because he's like, yes, I control a little bit of the narrative when it comes to this. Do you guys think the DNA, do you think whenever it does come to trial, do you think that the DNA is going to be understood not only from the judge, but from the jury as well? Because you can tell he's very confused. He's going to have to bring in independent, which is understandable. We're confused, you know?
Yeah. So the DNA that he's trying to understand right now is for discovery purposes, meaning she wants it, right? And then at the time of trial, that's a different story. The judge is going to have to decide whether it's admissible evidence, whether it's reliable or whatever. So if the judge is having a hard time right now, he's probably going to have a hard time deciding whether it's admissible. But I think this is a first step. But, like I said, I probably need a refresher because I think at one point I understood it. And now I'm like, oh my God, like it's overwhelming. But I think that we went over it and I think we understood it. We understood that it was a tool, an investigative tool. So investigative tools aren't necessarily admissible in a court, like polygraphs. So if he understands it and if he gives over the information to the defense, the next step is it admissible in court? So we have to wait till that next step. And if it is, the jury can understand it. I don't know.
If they're not even using it, I don't see, this is like just dragging out for nothing.
Well, that's what they say, they're not using it. But the defense says that that's how they nailed their suspect. So it's an issue in controversy. It's a controverted issue.
It's all tricky.
It is tricky.
I'm just wondering if I'm just worried there's not going to be enough knowledge. And when you're talking DNA,
yeah,
we all know since OJ's trial how important DNA is. It's been a long time since OJ's trial, and 30 years. And knowing how important it is, and now knowing how important it is now 30 years later, and how things can be interpreted in a completely wrong way, with how powerful that is, the mixture of interpretation and power is, it just makes me worry. It really does.
Yeah, it's like I said, it is difficult to comprehend. And so, look, if this DNA issue gets thrown out, maybe the case gets thrown out, and there won't be a trial. But if this DNA has substance and they're going to introduce it at trial, I am concerned too about the jury understanding it. And it's, I mean, I like, I would have trouble understanding it because, I do have trouble understanding it. I understand the gist of it, but we went over it a long time and, it kind of, I had it wrapped around my head, but then it kind of unraveled. No pun intended, but it did.
Unravel. I was you're on mute. I thought you were going to come in and slide in with I was going to let you have the stage. I thought it was your turn.
Anyway, I tried to make it funny.
Yeah. Oh no, I was laughing. I don't know. What does Ellie have? Golf clubs? What's up, Mama? Fine. What's up, Becky? Exactly. That's why it's so important over there in Un-rav-el's channel. That's why it's so important, when we're talking about this stuff. And we're going to be doing a show tomorrow night on the DNA. I got some other stuff. Shout out Storm OZ on Twitter.
Oh, good.
Reference me to some things as well. So we'll be going into this DNA, SMP, STP, SRB, a fucking SR, MR data, all this other shit. You know what I'm saying? We'll be going into all of it.
Like something like this, I did have a genetics case a long time ago, but something like this, all I have to do is ask the expert the questions and they answer. But I don't necessarily understand it. But the expert understands it and makes sure the jury understands it. And I swear to God, there are times when I don't even fucking understand it. But I have to at least understand a tiny bit. And in this case, I do understand a tiny bit. But yeah, you need an expert. It's new.
Yeah, that's what it's gonna be. I'm wondering, like, is he gonna hire? Like he said, he's gonna hire independent. So does that mean he's gonna be doing this outside the court?
No. He can hire. I mean, he can hire somebody who's independent, and as long as both sides agree that, yeah, he needs Vargas.
Yeah. Why would he have? Why not CC Moore? You know what I'm saying?
He could. I mean,
it was a good funny.
CC Moore.
What?
It was a good funny. I went to go unmute it and my hand didn't hit it right.
Oh.
I said that my knowledge of the DNA unraveled at some point that I can't.
It was good. I laughed.
Oh, okay.
I did too.
I was like, God, did I offend her?
No, I couldn't. I hit the wrong. Yeah.
Yeah, but literally, I knew it at one point, and then it just kind of like it unraveled. It's just like I have to relearn it again. But no, it's interesting, and the criminal defense attorneys should really know this.
Well, it's all new. That's why they still consider it an art and not a science. The people who are in the profession of it, it's all so new. It can be interpreted in so many different ways. And then with the article that I did a video of that I put out as a highlight, you can see the different ways that it could be misinterpreted based off of basic things. You know what I'm saying? So when you look at the beginning, right, and you look at how they first thought it was an unalive self-unalive, you looked at, can you say that there wasn't contamination from the get-go?
No.
You're already talking right there, and that's before, you know what I'm saying? So when you look at the article that I read, and you listen to those words or you read it yourself, because the link is in the description of that video, and then you compare that to the contamination that could have been possible before they even showed up, you have to consider that these things are possibilities, because that's why the handling, the transfer, all of these things are so important, because contamination can pop off so quick in so many different areas. And that's why we talk about these different cases of the same thing happening, where somebody was in an ambulance and their shit was transferred, which we heard that in Midnight Radio show. Shout out Midnight Radio. Mark Carver, where he shook the officer's hand after he was interviewed, and the officer went and touched the vehicle, and then his shit ended up on the door handle, and then he was convicted of the crime.
Okay.
Like,
yeah,
it's that simple.
Yeah. So two things I dreamt about. Sorry, about this case. One was the Pennsylvania U-Haul, and I had a dream that Brian used that U-Haul to transfer stuff to his apartment. And somehow his DNA was in that U-Haul and it got transferred onto somebody moving. I don't know. That was just a dream.
Most of the time, those U-Hauls are just getting transferred from one U-Haul to the next. Usually, they're not round trips; they're one way most of the time.
Correct. But anyway, that was just a dream.
They're a long time ago. Yeah, dream.
It was a dream. I'm thinking of this in my head. The other dream I had, and these are just dreams. I don't expect anybody. I just want to dreams. But I had a dream. Somebody said that Bethany's parents were attorneys, and I had a dream that Bethany called her parents, and they called her what?
Dylan's mom.
Oh, Dylan's mom is an attorney?
Yeah.
Oh, I didn't know that. In my dream, Bethany's parents were attorneys, and they were the ones that told her to call it in as an unconscious person because of the law. But those were just dreams that I had.
Because unconscious, or for the OD,
yeah.
the OD for the
OD.
amnesty.
Yes.
Yeah, I know, and that's why I think we're not hearing the 911. That's why I don't think it was DM that called it. Even I think maybe it might have been BF.
Yeah. So I just had those dreams, meaning that I'm thinking about this case in my dreams, and it's probably time I need to go to sleep now.
Yeah, we went through that Fight Club stuff like way back in the beginning of the year, so we already went through all that stuff. Now we're discussing the court hearing tonight.
Right.
But yeah, if you want to check some of our shows, we did it way in the beginning of the year, exploring the Fight Club stuff. I didn't see too much of it. That's why we don't really talk about it anymore. When it comes to I don't know. What do you think, Un-rav-el? We did the Grub Truck deep dive together. I didn't come away thinking there was a Fight Club. What about you?
I did not.
I didn't either.
I didn't either. Okay. Let's go ahead and finish up this court hearing, and then there is a couple snippets from the family's interview that Brian Nenton did, and I have a feeling there's going to probably be a special coming out Sunday. I don't know. I haven't heard, but I'm just kind of thinking they have this whole family interview that's going to be coming out Sunday night or something. I just got this weird feeling. Something in my
family of whom?
The Consalvas family.
Oh.
There's a couple snippets, but I think they're saving the whole thing, and I'm thinking they're going to do something on Sunday night with like a special report. I don't know nothing. That's what I'm feeling. I'm feeling it in my veins. I don't know.
Are all very educated about this already, so maybe I don't need to do that. We'll see. All right, but if this can be provided sooner than December 1, that would be fantastic.
Yes, sir, and that would be our intention. As soon as we have everything that is out there, it's our intention to put it together and submit it to the court and have kind of a list of table of contents or index, whatever I want to call it, of everything that's being provided to the court. I will say, listening to Ms. Taylor's recitation of all sorts of specific types of stuff, that based on our understanding, there are items that she thinks ought to be there that do not exist in the way of documentation form in any fashion. We will give you everything that we are provided with, and we have asked for everything that exists, both from the private lab and from the FBI, and that's our intention. But I don't think that the lawyers ought to get into the guessing game of what should and shouldn't be there, particularly since it is our position the defense has a fundamental misunderstanding of the difference between SNP profiles and traditional DNA comparisons and how that process works. When we start talking with statistics and those sorts of things, those don't necessarily apply in the investigative genealogy world. So I don't want there to be any false expectations, and I certainly don't want the court to be misled that things of relevance exist that do not.
Well, I understand that issue to some degree because...
So he's basically saying, look, just like I told the secret grand jury, what we've offered should be good enough. You don't need to see anything more. And he's basically sit there saying, look, we've offered things. We're offering everything that we can offer. It should be good enough. That's their argument. That's what I took away. You don't want the court to be misled, right? I don't want you to think that you need more than a stock photo, right? Like, just like what I said, just like he probably said to the grand jury, I don't want you to be misled thinking you need a stock photo when we have all this other information, we have all this other evidence. I don't want you thinking you need the background of the IGG information if they're not trying to offer it, because we didn't need that in order to arrest this individual. It's the same tactic, just different measures. That's what I'm seeing. Kelly Miller thinks there is a fight club. Way more common than we realize. Interesting.
I think that I seen something about a fight club, and I actually seen like but I don't think it was. I don't know.
It was a group in the back at the end.
Yeah, but you know, it looked like, I mean, it didn't look like they were looking at deaths. You know what I mean? Like people dying.
I mean, it could. You're right. Yeah, maybe it was them watching something.
They were,
I don't think. Yeah,
um,
because that was an extension of that theory. Was people watching the crimes take place, and I don't. That's why I don't even talk about it. Because
yeah, that's
I want to respect the victims and the families. You know.
Yeah, I couldn't imagine. I think that phones would have been dropped or something. Like that would be a lot.
Not that many people. Not that many people are going to keep quiet either.
Not at all.
Somebody's going to talk. Somebody.
Oh yeah.
Somebody's going to talk, brag, something. You know. For sure. So I don't know. I just, if there's more evidence, sure, I'll explore it. But we've already explored it in the beginning of the year, so it wasn't nothing. But I mean, I'm not saying it didn't happen. There's people in here that believe it did. I don't know. I wasn't there, but when we looked at it, I don't know. It didn't come across that there was. So.
I've been reading your briefs back and forth, so I understand that is a repeated kind of issue, and I think, excuse me if I'm wrong about this, Ms. Taylor, but they want to be able to see what has not been documented. So that's one of the issues that there's going to be a struggle about, and I understand that the process, the procedures of some of these IGG procedures are not documented. There might be some notes. I understand that the FBI has some notes. So let's start where we know we have things, and then we can go from there.
Yes, sir. And that's how we prefer to proceed. I was just reacting to the laundry list of things that Ms. Taylor was reciting that, based on what our experts have told us, don't necessarily exist in an investigative genealogy SNP analysis. They may exist in a traditional STR DNA analysis. And those are two separate and distinct processes. They do not overlap at all. So we want to make sure that there's no confusion, because some of the things that have been submitted by the defense don't accurately talk about the distinction. And that's why Mr. Nye, in our filings, submitted the affidavit from Ms. Nowlin at the Idaho State Lab, talking about the distinction, the difference between two separate approaches to DNA. I just don't want to muddy the waters. I don't want there to be false expectations created.
I understand.
Provide, as always, everything that we get, everything that we can find, everything that's provided to us, we will provide to the court for its review.
Thank you. And I understand it. They're very different. Okay, I think that's really clear in the order addressing IGG DNA. I also understand that the state and the defense have different lists. So I will look at it and I'll muddle through it as best I can. And
Muddle
I do
through it.
understand
That's not very. Those aren't confident words. Muddle through it.
the difference.
Oof.
And the reason why IGG DNA profiles aren't the same, okay, as our more traditional DNA profiles that law enforcement use and courts have been used for years.
Thank you.
Yeah. All right.
Your Honor, may I respond?
Sure.
I want to respond to the accusations that we're misleading the court and that we're trying to muddy the waters.
I didn't take it that way.
This is about the third time that these kind of pokes are happening at the defense, and we haven't responded to it. And Your Honor, I just want to respond that the information that I talked to you about, this laundry list, as Mr. Thompson says, a lot of that comes from expectations based on reading Department of Justice policy that was included for the court with our briefing before the August 18th hearing.
Right.
A lot of that information comes from the testimony of the two genetic genealogist experts that we put on and the information that they provided to the court at the hearing. These aren't made up things. We absolutely understand that the genetic genealogy investigative process is different than what the Idaho State Police Lab does with STR profiles. But there's analysis that happens along the way in building out these family trees to identify somebody. That was talked about in depth. We are not trying to mislead the court. We have been absolutely clear, and we've relied on Department of Justice policy in our expectations. So I just wanted to make a record of that.
Okay.
Your Honor, I'm not suggesting Ms. Taylor is intentionally trying to mislead the court. It's our position that they have been provided with information that's not accurate and it's creating false expectations. And I don't want the court to be misled by that and to have expectations that are not accurate. That's all.
Okay. Thank you both. And I really try hard not to get misleading information and then rely on it. So I will be very careful about this. This is really important. And it is, well, as I said in the order, this is a first impression in Idaho. And I want to make sure that we do it right the first time. That is exactly why I requested some information, the IGG DNA information, so that I could go through that and understand it better and make an informed decision for what should go to the defense and what maybe shouldn't. I can't make a decision about that yet. So, but I appreciate the separate positions that you both have, and we'll, like I said, do our best. So if something comes up between now and December 1st, as I said, you can ask for another scheduling conference or a status conference like this so that we can kind of iron out the wrinkles if there are any. Particularly if we find out from FBI that it's going to be, much longer period of time before we get it. Now, I sure hope that doesn't happen. So we'll see. It sounds like they're working at it. So that's reassuring to some degree.
I will be speaking with them this afternoon, Your Honor, to let them know and impress them. And I think they understand that this is time sensitive and we would like to see it happen sooner than not. My impression is they did not want to underestimate what the amount of time might be, and that's why we're looking at an initial ETA of up to a month.
Okay, great. All right. With that, anything else?
No, sir.
Okay. Ms. Taylor?
No, Your Honor, thank you.
Okay.
And that's why, he basically stated that in the beginning of the court hearing that they were going to have it for around a month. So it'll be interesting to see if it comes out, right? I hope it does. I really do. And maybe we could talk about that tomorrow too. The DNA and ex parte. Maybe that can be a topic. We can kind of do a combo. Talk DNA and ex parte. What do you say?
It's a wrap.
Let's do it. We'll talk about it tomorrow night. I'm going to go through a couple of these videos from News Nation, and if you'd like to unravel, I'll have a few minutes after that if you want to go through one of those videos. Detective Golden, are you still in the show? Type in chat if you're still in the show, because there was a certain video that Detective Golden wanted you to go over, and I want to make sure Detective's in the show, and if not, we can wait till tomorrow.
Yeah, I want to go over the video of the one she did. I didn't look at it. I saw it, but
I think one of the kids are holding something.
One of the what kids?
Those four
witnesses, or the who? What kids are we talking?
Banfield, the 4 kids running.
Oh, okay.
Or however many.
I know I need to finish that body cam, but I gotta wait till probably next weekend. I'll explain why when we start on the body cam stuff again.
Okay.
All right.
I'm interested to see what Yolie sees.
I'll look at it. Can I look at it?
Look at what? The body cam stuff?
The video that she did.
Yeah, I'm going to check out the couple minute clips of the parents real quick, and then we're going to get to that.
Okay.
Yep. One second here. Let me switch to this. Whoops, it's just me. Hold on. What the hell? There we go.
I knew in my heart what was best for those girls and Ethan. I knew what was best was to keep that around until they did more. And there'll be a point when I'll be like, you know what? Let it go. Let it go.
And our agenda of keeping it around isn't because
they're talking about the house.
Sad when it's torn down. I mean, that is going to be sad to me. And people think, how can that tear it down? And it's just like, look, my daughter lived a happy life there. Yes, she was murdered there, ultimately murdered, but that was this much time. We have pictures of them in the house. When that house goes, it's going to be hard. I don't want to go in it. I've never even been to the house. I've never drove by it. I don't want to, but it's still going to be when they're like, that house is gone. It is going to be very emotional for me. But that wasn't why the emotional side of things. It was strictly is this good for the prosecution? Is this good for the case?
10 days from now is November 13th, and that is 1 year ago. It is the date when the world came to a halt for a university town in Idaho. But the world really just stopped completely, just changed forever for the families of 4 students there. Their parents had shipped them off to college. But these 4...
All right, I'm just going to skip this part and go right to Brian Etman. Sorry.
Ashley, this has obviously been a difficult time for the victims' families in Idaho, the Goncalves family included. They say it's difficult to grieve when the court process is ongoing and frustrating for them because it's been so delayed. They did have a bit of a victory, though, they feel. You remember they fought to keep the house where the murders happened standing. The University of Idaho wanted to tear the house down. The Goncalves family fought it. The house ultimately was not torn down, and it turns out the FBI has now gone back out to the house. We reported on it this week. They went back out to the house to do 3D imaging. I spoke to the Goncalveses about that, and also just about the court process and what they want to see happen in general.
I knew in my heart what was best for those girls and Ethan. I knew what was best was to keep that around until they did more. And there'll be a point when I'll be like, you know what? Let it go. Let it go.
And our agenda of keeping it around isn't because, it's going to be so sad when it's torn down. I mean, that is going to be sad to me. And people think, how can that tear it down? And it's just look, my daughter lived a happy life there. Yes, she was murdered there, ultimately murdered. But that was this much time, we have pictures of them in the house. When that house goes, it's going to be hard. I don't want to go in it. I've never even been to the house. I've never drove by it. I don't want to, but it's still going to be when they're like, that house is gone. It is going to be very emotional for me. But that wasn't why the emotional side of things. It was strictly is this good for the prosecution? Is this good for the case?
If he pled guilty and said, I'll plead guilty in exchange for a life sentence, have you thought about that?
Yeah, I don't want that because I studied the criminal system and the difference between life and prison. Even if it's 20, 30 years, he's 23 hours locked up. He doesn't get to do what is it, BTK killer? PTK. Or whatever. We've found out that he writes papers for other prisoners and gets treated really well because he's intelligent and he's able to help other prisoners get preferential treatment through the legal system. We don't want that type of behavior to happen in our case where he has influence outside of this event. So
that's been a hard one, though. I mean,
he could write a book. He can do things. Idaho doesn't have a law particular that protects against that.
The hard thing with that question, honestly, is that's where you forget, and I don't know how it's possible, but you forget that there's 3 other families involved here. We're not the only ones.
Have a good night as well.
This is not a one,
one crime fits all.
This is
right.
This isn't just our daughter.
Right. Some might not want to go through the trial.
I know some of the other families definitely would be, yes, let's go. Where do I sign? And I understand that 100%. 100%. I understand that. But you know what? Ultimately, it's not our call. I mean, they might ask us our opinion like they did on the death penalty, and we'll give it. But just because, our opinion is yay or nay doesn't mean that, that's what we get.
The Goncalves parents have said that they are for the death penalty in the Bryan Kohberger case. But again, it's just frustrating for them how long all of this is taking. They have to take vacation days and plan their whole life with work around when these court hearings happen. And many times the hearings pop up at the last minute. This all while they continue to try and grieve for Christy, Kaylee's mom. She says that it's difficult for her to go through Kaylee's things and to go into her bedroom.
But I've only been up to Kaylee's room. I mean, it's right up there, right at the top of the stairs. I've only been up there twice. And neither time was for any amount of time. It was in and out. Oops, in, out. That's all we have. That is it. And it's just real. It's just so real sometimes. And it's just the worst that somebody could do this to somebody's family. So many families.
The Goncalves family really is just so strong despite everything that they've been through. Obviously, this is an especially difficult time with the 1-year mark of the murders coming up on November 13th.
Thank you for watching. Go to newsnationnow.com to find.
Not with you. All right, so we're going to switch to Un-rav-el's channel. Here's the link if you're not subscribed. All right, so what video are we checking out here before we end? And yeah, I'm going to be setting out a note. What works best for you, both 6 o'clock Central or 7 o'clock Central?
Just let me know.
What about you, Yolie, for tomorrow night? You're muted if you don't know.
Yeah, so 7 o'clock Central. That's 5 p.m. for me, so 7 o'clock Central.
That's better? Okay. I'll go ahead and make it 7 p.m. Central. And...
So
I'll make it available. I'll make it available for the live, but it's going to go to members only after that, maybe. I might. But go ahead.
That 148 video.
148 video.
To the left of that one.
This one right here.
Yeah.
Where the guys are running. Okay.
That's the one that I wanted to see, but I don't know if there's any other.
Yeah, by the way, Un-rav-el, I love this intro about this Un-rav-el news thing. That's pretty cool. I like it.
Thank you.
Yeah, we watched this earlier in the show this morning, and I was like, fuck yeah, this looks badass. I love it. I love it. Made me think of Back to the Future there.
3, 4, almost as though they're walking in single file.
Oh, I thought I muted her.
At 3,
you see?
I see that they're holding something.
Yeah. In his arms.
And I see
Look at it right there.
Here, let me rewind it. I'll get us out of the screen here. So I'll go full screen on it. I'll get rid of this and we'll go ahead and play it now. Here's the link to this video. If you want to go show some love, please do.
1, 2. Yeah, they're holding.
I can't tell what it is.
God, it looks. I don't even want to say what it looks like.
I was thinking that sign or like a box or.
Oh shit!
Did you?
Oh, do they have gloves on?
I don't know. I just saw something. I don't know. Wow.
That's so strange.
Definitely go show some love on this video.
Jeez.
Play it in full screen on your own screen too. Go full screen on your TV. I'll go ahead and rewind it again. Go full screen on your TV on your own time too, and check it out. We'll go through it again tomorrow night.
Yeah, I mean,
I think this is the one Detective Golden was talking about too, and so we'll be going through it again for Detective as well. We'll go through this in the intro. Take a look overnight and come back with some notes, everybody. I'm gonna check it out myself on my big screen. Good video. Thank you, Un-rav-el.
No problem. The big screen definitely helps.
Yeah, I'll put it on.
Yeah, that's what I'm going to do after the show. One of my prep is going to be watching this thing on the big screen over and over and over and over and over and over.
See, I'm not sure if the guy holding something ducks down and his head's not in the view. I can't.
It look. Oh God, I don't even want to say what it looks like.
Well, come back tomorrow night. We'll talk about it in the beginning. We'll put a graphic content trigger warning up there, and we'll have a small section in the beginning where we'll get through it real quick, and then,
Yeah.
Because who said, I might see something different. You know what I mean? So we don't have to say it specifically, but we'll just have a small section where we can talk about what each one of us thinks it is, and then we'll.
Oh boy. Yeah, I'm gonna put it on my big screen.
Yeah, let's do it. Let's do it. We'll do that in the beginning of the show, and I'm sure Detective will be in there, and Detective will appreciate it too. So, one more time. If I could
put it on a big screen and record it on that kind of way to see if, because I wonder.
Let's do it. We'll get into it in the beginning. It'll be like the special breaking news. Breaking news. This is what we came up with from this video. Other people have questioned 5 as well. I need to get Midnight Radio on here with us sometime too and join us on panel. Maybe I'll see if I can reach out and see if Midnight Radio would like to join us tomorrow night when we talk about the DNA, the ex parte, and this video too.
Yeah, there might be a 1 or 2 extra people.
I don't know. Now I only see 4, but
before head, but it looks like one comes in and down like you. I don't know if you can actually see that person. You can see him like the tip of his.
The time. Yes, I did see that. I'm gonna look at it on my big screen.
Yeah, I'm gonna have to do the same. I'm only seeing it. Yeah, it's not. I'm just seeing it off the screen yard.
You can see, like one of them at least, the very top of the car. You can see him like peek over and then duck.
Yes,
actually, you can see 2 of them do that.
Yeah, I definitely need to see it on the big screen now. We'll be back at 7 o'clock Central, 8 o'clock Eastern tomorrow night. We'll be talking this in the beginning and then the DNA and ex parte.
Okay.
With Un-rav-el and Yolie. I think it's catchy, right? Why not go into both of it?
Yeah.
The DNA and ex parte.
I know, Katrina. Wow. Yeah. Okay.
Yeah, let's do it. Let's watch it on our screens. Let's come up with some notes. If you're just comfy in chat, bring them in chat. Let's talk about it tomorrow night. Panel members before the show. I'm going to see if Midnight Radio would be interested in hopping up with us tomorrow night as we discuss this as well. So if anybody has able to reach out to him, go ahead. I'm going to see if I can do it myself. We'll be back here tomorrow night. Appreciate you guys so much. Thank you, everybody. And thank you, too, for hopping up here, being on panel tonight as well. So nice to have you both again.
Yeah.
Thank you so much for your time and your company and your conversation. And everybody, thank you so much for being about the peace, positivity, and progress. It means everything to us in the community. And it's just what we're about. Thank you so much, everybody. Appreciate you.
Good night.
Appreciate you, too. Good night and bye.
Bye.